I am going to call the meeting of the Judiciary and Public Safety Committee to order. We do have a quorum. As a reminder, this morning, as per usual, attending this hearing, you agree to adhere to the standard expectations and decorum of the committee as explained in the written document available with the committee handouts and any additional verbal instructions that I or any other chair may add. We are going to begin this morning with Senator Oumou Verbeten. I think we are starting with Senate File 4951. Is that correct?
That's correct, Madam Chair.
Senator Oumou Verbeten, to your bill. And I believe this will be laid over, correct?
That's correct, Madam Chair.
Go ahead, Senator.
Thank you so much. I'm excited to start this conversation with the committee today on juvenile fines and fees. I've been really proud to work with the National Center for Youth Law on this. We'll hear from them and some testifiers about the impact of fines and fees, but I'd like to start by sharing a little more information myself. The bill that we have before us really just takes any language in law that we have, fines and fees, and strikes that. Fines and fees are assessed after adjudication for an offense. And there's kind of different fees. Some fees are related to maintaining conditions of adjudication, think like probation fees, but there are other fees that go directly to the courts or to general funds that don't have anything to do with the rehabilitative intent of the juvenile justice system. And that's really what this bill is trying to get at. They sometimes are ways to kind of fund general operations, but the issue is that most often they're unable to actually be collected because the youth and the families cannot afford to pay them. And so what happens when youth are unable to pay these fines and fees, they're considered indigent, as most youth involved in the juvenile legal system are too young to obtain employment to pay that debt. And then that can be, an issue for their family taking on that debt. And we know these are a lot of families who are already suffering with financial burdens. Jurisdictions who track socioeconomic status have also confirmed that nearly 60% of youth involved in the juvenile legal system come from families that bring an average of less than $20,000 in a year. So to those families, an added expense can drastically affect livelihood, adding the risk of being sent to debt collectors, wage garnishment, etc. The question often asked is, where will the state recoup the funds that it will lose from eliminating fines and fees? But again, the collection of these fees statewide is actually pretty low. For counties, we know that they're not bringing in enough revenue in juvenile fines and fees to support a single full-time employee. In Minnesota, statewide collection between 2022 and 2024 was 56%, a little over half of what the courts were assessing. In Hennepin County, the collection rate was only 26%, and that actually included restitution. And there's just not any uniformity in assessment. We see varying amounts of fees that are collected across counties, across the state. But I do want to be clear that there's different fees that are kind of listed in this bill. We don't have very clear data on medical care and treatment, and so there you have a letter from the Association of Minnesota Counties. I spoke with them. They're really referring to sections 2 and 6 of the bill. And that current law allows counties to work with families to assess their ability to pay for medical services. So that's looking at things like insurance coverage or the financial ability to pay. And so I'll be continuing to work with them. I really want to get a better sense of what those costs are and make sure that they're able to maintain their ability to seek reimbursement where it does make sense, especially when there's not a burden to youth or family. And again, that might be things like accessing the insurance that family has to cover medical expenses. But today, this is really just to open the conversation at the committee, get that feedback. I'll be continuing to work with stakeholders on this bill in the interim, and look forward to hearing the questions that the committee may have. Just a few more points that I want to make. if youth were being kind of assessed fines and fees for accountability, that's a question, but we see a lot of other measures that we can take in order to assure accountability for youth that I think is a better fit than just a fine or a fee. And we've also seen states across the country recognize that juvenile fines and fees do more harm than good, and they've worked in a bipartisan manner to eliminate them. In 2020, Texas passed a bill to eliminate fees statewide. Montana also passed a bill eliminating all fines and fees and erasing debt. So this does show that it's possible. I think the bottom line is that the debt that families incur really does have more of a disproportionate impact than the actual amount of money that could be collected statewide. And so that's the conversation we're looking to open up today around, does this make sense to actually assess those fines and fees when we're not really collecting anything and we know that it's really harming families. So I look forward to hearing the testimony and hearing from folks that have been directly impacted. Thank you.
Thank you, Senator. And we do have some testifiers, and I think they may be remote. The first person up is Miranda Sheffield.
Good morning. I actually am going to yield my time for just Q&A for folks.
Okay.
But have someone in the room who's present there actually. Christy Snyder with Youth Prize. And then we have 2 people online that are going to be testifying.
Thank you for clarifying that. Is Ariana Claire available?
Hey, yes, I am.
Thank you. Can you introduce yourself for the committee and then go ahead with your testimony?
Hi, good morning, everyone. My name is Ariana Claire. I am from the link. I am here today to testify because I have experienced firsthand burden of youth fees and fines, and I urge y'all to vote yes on SF 495. When I was charged with these fees, it was a hard time. I was pregnant, I was in school trying to work, get stable, trying to find stable housing, trying to become financially stable. I would say the total amount was around 8 to 9, which is difficult for me alone so far. It's just me. But when I did first officially find out, like when it was gonna start affecting me is when I wanted to drive. I felt stressed, I felt overwhelmed, I felt frustrated because it came out of nowhere and I'm young, it's just me and my baby. So I was already struggling financially, already trying to figure out childcare, already trying to figure out how I'm gonna get back and forth from school and job with her to a job with her. And then these fees is stopping me from driving. I feel like I've been having trouble paying bills, trying to decide on what I need to prioritize first because the older I get, the more they prioritize and push me to pay these things. I really honestly don't know what I'm paying because I'm 22 and these fees came about when I was 15, 16, 17. So I get probably about like 3 calls from debt collectors a day telling me, constantly reminding me to pay these, pay this. And I'm just like, I gotta live first. I gotta pay. My baby getting me new clothes every other day. So it's just like I can't afford to pay for fees that I don't know what I'm paying for and fees from when I was a juvenile. I just feel like no young person or family should have to go through these kind of financial and emotional stress because of fees like these. I feel like passing SF 4950, you can help prevent other families from experiencing the same burden I did. So thank you for your time and consideration.
Thank you, Ms. Claire. Thank you for your testimony. And do we have Shamie Robinson also online, I believe? If you can come off of mute and go ahead. Thank you.
Yes, thank you. Good morning and good afternoon, and thank you guys for taking this opportunity to hear me speak. My name is Shami. I am currently 23 years old, and I'm here to share how court fines and fees have impacted my life and reform is needed. I was first charged when I was 17, and I'm now 23, still dealing with the effects of almost over $1,000 in fees. These costs have afforded me to choose between paying what I owe and meeting basic needs like food, housing, bills, and childcare for me and my child. That has made it difficult to maintain stability moving forward. Because I have not been able to afford these fees, I've also struggled to obtain my driver's license as well. And that has led to additional tickets being created and creating ongoing barriers to transportation and work and more opportunities for me and my child. Over this time, it has affected my credit and resulted in collections, and it kept me stuck in a cycle that's hard to break. My experience shows that fines and fees don't just punish for a moment, they also create long-term consequences that follow people for years and blocks pathways to stability. That's why I support this bill, and I would help reduce ongoing burdens and give people fair chances to move forward instead of being trapped in debt at such a young age. Thank you guys for your guys' time and consideration.
Thank you so much, Ms. Robinson. And then was there anybody in the room that wanted to testify? Thank you. Good morning. Thank you for being here today. State your name for the record and then go ahead with your testimony.
Hello, everyone. My name is Christy Snyder. I'm at Youth Prize. I'm the Policy and System Transformation Officer. First off, I'd like to say happy third deadline to all that celebrate. And I'm saying further indebted to you, Senator, for bringing this forward. Youth Prize is a statewide intermediary that focuses on young people, particularly young people that are low income. And as you've heard from these powerful young people who testified, I just hope everyone is sitting with what you heard just now, because you hear that it has long-term impacts. It's not just a punishment that happens, which it is a punishment that happens, those fees, but it has long-term consequences for them to launch. And I want you to hold that as you think that forward. I also just want to say, in addition to everything that Senator Oumou Verbeten said just now, I just know that there is tension in the bill about health care. And I want to remind us that when families are forced to have young people leave their house and out-of-home placement, they might have treatment due to trauma and other things that are happening during that time. And it is incumbent on counties to think about how those families that do not have health insurance are enrolled at entry. And so while I know that there is tension, I don't want us to lose sight of the fact that every young person should have Minnesota Care or medical assistance. And so we can't let that derail this bill. Fines and fees are setting up young people for failure. As we know, it's a bipartisan issue. We understand that this is something that has long-range impacts, and it's important that Minnesota get in line with other states that are really making a difference in young people's lives. So I'm grateful for this bill coming forward. I'm grateful for you to consider it, and I hope that you consider it as a whole and not take out those initiatives that the sections that were originally stated from the Minnesota Association of Counties. Thank you so much.
Thank you for being here, Ms. Snyder. It's good to have you here. Okay, members, we are going to, I don't believe there are any other testifiers on our list today, so we are going to open this up to any member questions and discussions. Senator Holmstrom.
Thank you, Madam Chair. I read through this bill and for the purpose of getting feedback and having this discussion. A couple things were mentioned. The first was that there's long-term negative effects and burdens of these penalties. And I think that what we're forgetting here is that crime has long-term effects and burdens for the victims. And that's, it's hard to find sympathy for the burdens of, on behalf of the delinquencies when the victims are not being addressed by the same problem. So there are other means of implementing accountability, you're correct, but we're not talking about those right now. We're talking about removing accountability. And to this, and to that lack of accountability, I would point at the obscene amount of car thefts in Minneapolis and St. Paul that we're seeing. Hennepin County, I think I saw 1,500 vehicles already this year have been stolen, and we know that a large percentage of those thefts are being committed by minors. And just on April 2nd, 2 minors were shot while stealing a car. And if we continue to have permissive laws that are not holding these young people accountable, we're inviting more young people to partake in these activities and put themselves and the community at danger. And I have sympathy for the victims of all these crimes, and I have sympathy for the 14 and 16-year-old youth that were shot because they believed that they were going to get away with this without any consequences. Now, of course, what happened to them was a result of their own choices. But when we as a legislature incentivize that behavior because we refuse to hold it accountable and start pulling away more accountability, we're only inviting more of this, and we're creating the problems that we're trying to solve. So I find it really hard to even have a conversation about pulling these away because we're not having those other conversations about increasing accountability. Thank you.
Thank you, Mr. Holmstrom. And Senator, I have a couple of questions for you about the scope of this bill. My understanding is that your bill removes fines and fees, including the following: a $25 penalty for not wearing a seatbelt, payment of medical fees for care required in juvenile detention, so it goes to the medical care, up to the $1,000 fine for children who are found delinquent. It doesn't really talk about what offenses that might be, but perhaps you can discuss that momentarily. Up to $1,000 fine for major highway or water traffic offenders, up to $100 fine for children who are found to be petty offenders, and then for the cost, care, examination, and treatment of a child whose legal custody is transferred to social services, and then a minimum fine for $100 for underage consumption. So that's my understanding. Can you describe a little bit more about what fines and fees are covered here, and maybe respond to, in that process, also Senator Holmstrom's remarks? Senator Oumou Verbeten.
Thank you, Madam Chair. That's correct. I think you did a pretty good rundown of the fees. One of the things I want to point folks to is you'll see some of the existing things that the court can do in Section 5 of the bill, starting on page 6, line 22, participating in community service projects, drug awareness programs, chemical dependency evaluation, probation, of course. We know there are youth that end up in detention centers. There's also restitution to the victim. I think there's a number of avenues to ensure accountability, and that's really important. I hope folks know from the work that I do here in the legislature that supporting crime victims is really important to me. That's why I've carried the Crime Victim Services funding. I think we'll have an opportunity to talk about that a little bit more in our committee later today. And really, this is not removing restitution. This is removing fees that are assessed that are kind of going to courts or general fund, which again, we're not even able to collect that much, but we know the disproportionate impact it's having on families. And so, I would prefer that we do focus on those measures of accountability, those interventions that we know will make a difference in those lives and hopefully lower recidivism in youth. That's important so that we can get them on the right track, employed, becoming contributing members of society, and I think that's the path we should be going towards, rather than kind of cycling folks in and out of the system or keeping them in a place where they're unable to contribute. And there might be more that Miranda Sheffield would want to share too from the National Center for Youth Law. I also think Chair Latz has his hand up.
I see that Chair Latz is waiting very patiently. We'll go to him next. Chair Latz.
Thank you, and I apologize for not being there in person. We've got both car troubles and one telephone down in the family, which has really messed up the whole morning. So I just wanted one clarification, whether or not this proposal includes waiving or eliminating restitution. for any losses that the victims experienced.
Senator Oumou Verbeten.
Thank you, Madam Chair, and thank you, Senator Latz. No, and that's why I was pointing to the existing language that, you know, allows for the courts to make, to order restitution to the victim, which I think is very important. I think that's about making people whole. That's different from the fines and fees that I'm working to eliminate in this bill.
Senator Latz.
Thank you, Madam Chair. So I guess I look at this differently than Senator Holmstrom does. He said this eliminates consequences, and I don't see it that way. There are lots of other consequences of going through these proceedings for the defendants or the alleged juvenile delinquents, including probation, social services. Sometimes there's jail or alternatives to jail, depending on incarceration, placements, all sorts of different things that are involved here. But these are also youthful offenders, which mean who are held under the law to be rehabilitatable, and that is the primary focus of those efforts as well. So the only proposed adjustment, as I understand the bill here, is to adjust the financial consequences that will be carried by the offenders as they proceed on. And we recognize these financial burdens as exactly that, burdens, and in some cases they're significant and they're important, and that's fair. But for someone who's earning $1 million a year, it's less of a burden than for someone who's earning $10,000 a year. I mean, that's just a basic economic principle, we also want these individuals to be able to launch successfully, as has been noted already. And society has an interest in doing that, because then they are more likely to become productive, tax-paying, law-abiding members of the community, rather than continuing on as burdens of the community or committing more offenses or antisocial conduct. So it's in all of our interests for them to be successful, and to the extent that we can minimize the ongoing financial burdens that would impede that success. I think it's worth it, and frankly, from what I can tell, it's not any other individuals like victims that are bearing the financial cost of this proposal. It's the taxpayers in general that would otherwise be picking up the cost of these, of eliminating these fees and fines. And to me, that's a worthwhile investment for society, given what we expect would then be the long-term benefits of taking these steps. So for those reasons, I think it's a good effort, it's a good bill, and we ought to be moving with it. And I understand, we've got fiscal issues this year, and we might not be able to proceed to enact anything this year. But this is the right direction that we should be going, in my judgment. Thank you.
Thank you, Mr. Chair.
I'm going to have to jump off. Okay. I'll get back on as soon as I can. Thank you.
I do have another question for you. So in the state of Minnesota, for juvenile offenders, juvenile offender can remain in the juvenile court system, which is considered delinquency, potentially child in need of protection. Those are all under the juvenile court auspices. We also have something called extended juvenile jurisdiction, which basically is sort of a hybrid place where kids who commit more serious offenses are under the jurisdiction of the juvenile court for a longer period of time. And then we have the process of certifying juveniles who commit very serious crimes as adults. My question for you is, and maybe this is for you or for counsel, but does your bill deal with the fees and fines only for young people still in the juvenile system, or does this impact the more serious crimes that we heard about, the EJJ crimes, kids under that jurisdiction or certified as adults? Do you want to phone a friend?
I'm not sure I know the exact answer to that question, Madam Chair. Council can weigh in.
Madam Chair, members, I think for kids certified as adults, this would have no impact, because that becomes an adult situation. But for all the delinquencies, including the EJJs, this would apply, because an EJJ is a blended sentence. You get a juvenile sentence where this would apply, and then a state adult sentence. So it would affect that.
Thank you for that clarification. Senator Holmstrom.
Thank you, Madam Chair. I have a question for council. We spoke about the scope of the bill and what it might entail. Is this just misdemeanors and seatbelts, or would this extend to all gross misdemeanors, felonies, and beyond?
Mr. Backus.
Madam Chair and Senator Hallstrom, as I said a second ago, it would apply to any delinquency, including any delinquency matter, which could be gross misdemeanors and felonies, including serious felonies.
Senator Holmstrom.
Thank you, Madam Chair. So I want to make this point again. We're facing a serious, we're seeing a serious amount of youth committing crimes that are going underpunished, and a lack of accountability for that. This measure looks to remove more of that accountability. And the result of that, as we've seen, is youth are committing more crimes without the system imposing consequences, and they're being put in serious danger. The community is going to the world will implement consequences for actions. And in our lack of action, our lack of being willing to hold people accountable, 2 juveniles were shot committing a crime because they believed they'd get away with it. That's the real world cost of weakness in this body. And I can't support a measure that's going to continue to allow for that and make it potentially even worse.
Senator Oumou Verbeten.
Madam Chair, I just wanted to give Miranda Sheffield an opportunity to weigh in, and
Okay.
I'll have some additional closing thoughts.
Okay. Ms. Sheffield?
Yes, thank you so much to the committee for giving me the opportunity to speak. My name is Miranda Sheffield. I am the director at the National Center for Youth Law, and I just wanted to respond just quickly. I hear what Senator Armstrong is mentioning about the need for accountability and also not letting these issues go unaddressed. I think the concern is the implementation of what accountability looks like in practice. I want to bring some data into this conversation. Between 2019 and 2023, there was a total of $1.3 million that was paid for fines and fees for juvenile delinquency, juvenile traffic, and juvenile petty offenses during that time. And this equates to less than about $262,000 that was assessed annually. That was collected for these issues that I just mentioned. And it was specifically for fines, not court causes, surcharges, or other expenses. And so what is happening is that when these young folks are being assessed these different fines particularly, it is after the harm has already taken place and they have already addressed the harm and already been held accountable by the courts. And then they are now having to deal with government overreach and burdensome bureaucratic process where they are having to deal with not just the lingering issues of additional monetary issues for them, but they also are having to experience what I like to call a double tax, where the issues are already being addressed for them, but now they're having to have a government that is continuing to stay in their lives by following them through what the young folks said on this call so brilliantly, better than I have. And then lastly, the other thing that I would like to point to is that I just want to make it very, very clear that this has nothing to do with restitution being able to be recouped and making victims whole, that this is speaking directly to the burdensome nature of how fines and fees are implemented, and that there is a huge amount that is being assessed but not being collected. So there's an inefficiency and how these fines and fees are being put forward. I think that we would be having a different conversation to what Senator Armstrong is raising, is if there was actually amount that was being collected that was over 60 or 70% of these fines and fees being collected, but the data does not show that these fines and fees are being collected. What it shows is that the state, the counties are not able to even recoup anything close, maybe 20 to 30% of these fines and fees. So it's an ineffective way of how we're putting forward accountability. It looks good on the books, but it's not good as far as implementation. Thank you so much.
Thank you. Senator Koran.
Thank you, Madam Chair. The bill is presented as eliminating fines for delinquencies or crimes committed by youth. But I'm looking at page 1, line 21, and you're striking language there that, and this is with regard to seatbelt use. You're also striking the fine of the driver of the vehicle where a passenger is a youth, and they would be subject to a fine. So in this case, aren't you eliminating fines for adults as well?
Senator Oumou Verbeten.
Thank you, Madam Chair. This is Judiciary Committee, so I expected that would come up. And knowing that this bill is laid over and that there was more work that would be done, I have had those conversations with folks. When this was initially drafted, it just struck the language anywhere we saw the fees that were assessed for youth. But you're right, that it would remove those for adults. It's not my intention. That's maybe a different conversation we would want to have and something that would need to be addressed in drafting. But knowing that we were just going to be laying this bill over today and that my intention is to remove fees for juveniles, I wanted to focus that conversation. But I have noted that for drafting. Thank you.
Senator Kroon.
Thank you, Madam Chair. And another note for your drafting then would be on page 9, lines 26 and 27. The fine against underage drinking, you have striking it for everybody under 21 years old, but of course that would also apply to 18, 19, and 20-year-olds, adults. So that would be another area where the fines are being eliminated for adults, so you want to look at that. High level, as we heard, this bill would eliminate fines for all delinquencies by youth, which delinquencies is just another word for crimes committed by youth. And my concern here is people often have a certain way of thinking about delinquencies or youth crime, but as shoplifting or underage drinking and that sort of thing. But really what we're seeing lately is an escalation of crime by youth committing more serious and serious crimes that we normally would consider adults committing. And that could be for a variety of reasons, but I think that it's happening. And we should not be lessening accountability, particularly across the board, for all crimes, including gross misdemeanors and felonies. These are very, very serious adult-like crimes that some of these minors are committing. And if you're the victim of that crime, it doesn't much matter to you whether or not the person who committed that crime against you is 16 or 17 or 18 or 19. You're still the victim and you're still terrorized by some of these serious level crimes. And so, of course, this doesn't remove all accountability for youth crime, but it does take away a very common tool for accountability, which is the fine. And so from my perspective, if you're a minor or an adult, but either way, if we're talking about minors here, we heard testimony that fines are hard on families. Well, from my perspective, it should be hard on the families. And I say families deliberately because it shouldn't just be hard on the minor that committed the crime. It should be hard on their parents as well. And it should be a financial hardship to deter them, to teach them the seriousness of breaking the law. This is a teachable moment. And if they go without any consequences now, or in some cases none, but lessened consequences, they're going to learn that there aren't many consequences for breaking the law. And that's a terrible message to send to our young people. In my view, it's the exact opposite. If we want to set them up for success, we should have more accountability when they break the law when they're young, so they understand the seriousness of it, and they don't get used to thinking it's just okay to break the law. And that will set them up for success more in the future. To me, the collections argument, the percentage of collections that are being so what? That is beside the point. This is about accountability and justice. And if there is a problem with collections, then we should look at the collections to make sure that we collect a larger percentage of the fines that we assess. Fines are supposed to be painful. They're supposed to be inconvenient. Teaches the seriousness of breaking the law. And it also respects the victims. I understand this bill doesn't take away victim services or touch on restitution. But if you're the victim of a crime and you see that your perpetrator wasn't even fined for the action they commit, I think that's a second victimization for that person. So we need to respect the victims. And we also need to keep in mind that there are already in-law hardship provisions in sentencing. Judges can take hardship into consideration when they're assessing fines. And we should trust our judges to do that in the appropriate situations, but to have a blanket ban on fines for all youths that commit crime is too broad and is not the direction we should be going.
All right, I do not see any further discussion. Senator Oumou Verbeten, last remarks before we lay the bill over.
Thank you, Madam Chair. Appreciate bringing this conversation to the committee today. And I think what we see with the financial hardship that youth and their families are going through, you know, we heard about folks who had fees that are continuing to see collections. It's affecting credit, the ability to drive. That's going to impact someone's ability to get employment. Again, things that will allow them to be contributing members of society. And I think working on really making sure that we're rehabilitating juveniles is the direction that we should be moving in, especially because we are just not collecting a lot from these fines and fees, but we are having a disproportionate impact on the youth and the families who are being assessed. So appreciate the conversation and look forward to working with folks on this more.
Thank you, Senator Oumou Verbeten. Senate File 4951 is laid over. We are going to be taking up Senate File 4739, and I think that is being passed out at this time. Senator Limmer, I'm so glad you came because I did make you a cake. And I was worried you weren't coming. Senator Limmer.
The only question I have is what flavor is it?
Well, I'm so glad you asked. It is a lemon rosemary olive oil cake with pistachio whipped cream and fresh fruit. It's
Okay.
healthy.
A healthy cake, okay.
It's a healthy cake. All right.
The cardiologist would love it.
Senate File 4739, Senator Oumou Verbeten, two-year bill. I understand you have an A1 amendment. Do you want to? Oh, okay, it's the A2 and it is in our packets. Would you like to move the A2 amendment?
Yes, Madam Chair.
All right, and this is the first hearing, so this is an author's amendment. Senator Oumou Verbeten moves the A2 amendment. All those in favor say aye. Aye. Opposed? The A2 amendment is adopted. Senator Oumou Verbeten, to your bill.
Thank you, Madam Chair. Senate File 4739 regulates the use of automated license plate readers, or ALPRs. They are cameras that, these are small, high-speed cameras that capture and store data on license plates. They can scan and record thousands of license plates in a minute. And there are some very, legitimate uses for ALPRs by law enforcement to solve crimes. And this is also very powerful technology that can reveal really personal information and be used to survey the population. And so, when we first allowed for ALPRs in 2015, we recognized that and wanted to make sure there were really strong data classification around that. Now as we're kind of seeing that be implemented and seeing the third parties that are providing this technology, I think it's time to revisit those statutes and make sure that we have some really important restrictions on how private data can be used. Some local law enforcement agencies are essentially providing federal enforcement agencies with warrantless access to individuals' private information. And the companies that are providing this technology just haven't been adhering to the Data Practices Act. So really what this bill does is prohibit the ALPR data from being assessed, disseminated, or shared outside of Minnesota unless required by a court order or judicial warrants. It also reduces the timeline for ALPR data that's not related to an active criminal investigation to be destroyed down from 60 days to 60 hours to 48 hours. And that aligns with the policy that's been adopted by the Minnesota State Patrol. It requires that ALPR data only be shared with a separate law enforcement agency pursuant to a written agreement. And it moves the biannual audit of that data to an annual audit and just ensures there's reporting requirements. And then there's also a section on private use of ALPRs, requiring that person collecting that data post a sign or number of signs prominent enough to inform the driver of any vehicle that a camera with ALPR systems in use prohibits a person from selling, transferring, sharing, or disseminating LPR system data without that affirmative consent, court order, judicial warrant, and then it classifies that data as personal data for consumer data privacy. And I do have John Bueller here with the ALCU who can share more information and help answer questions for the committee as well.
Thank you, Senator. Mr. Bueller, go ahead and introduce yourself and go ahead with your testimony.
Morning, Chair Westland, members of the committee. Testifying today in support of SF 4739 as amended, the current use and capability of license plate readers far exceeds that what was contemplated when the statute was written in 2015. Over the last decade, use of ALPRs has exploded, particularly through the involvement of private companies. Technological capacity and physical infrastructure now make it possible to run a massive number of searches in an instant without any oversight or real-time knowledge on law enforcement's part that their networks are being searched. We know that these license plate readers have been used improperly around the country to conduct civil immigration enforcement, surveil protesters and activists, surveil schools, families, students, and teachers for immigration purposes, investigate women seeking reproductive care, verify residency for public school purposes, give traffic tickets, and at least in one instance by local law enforcement to track their ex-girlfriend. The ACLU of Minnesota can confirm through its own data request that these ALPRs were used during Operation Metro Surge for civil immigration enforcement by in-state and out-of-state law enforcement. The use of these third-party systems has led to vast differences in how local law enforcement agencies interact and use these systems, and thus uneven privacy protections for Minnesotans depending on where they live. We sent data requests to various law enforcement agencies around the state, and particularly around the metro. One agency, Suburban Police Department A, received 180 requests in 30 days. At the other end of the spectrum, Suburban Police Department B received 425,000 requests in the first 6 weeks of this year. This is not just a Metro Surge issue. An ex-Urban Police Department received a response from in the fall, prior to Metro Surge, received 13,000 searches on their 2 cameras in 1 month. The statute was designed so that when one law enforcement agency receives a request from another, Minnesotan or otherwise, for ALPR data, the receiving agency would be able to ensure that Minnesotans' data was protected. The agency would verify that the data requested was related to an active criminal investigation, and that the requesting agency understood and would adhere to Minnesota data practices laws. It's no longer the case. The introduction of third-party companies has, at best, obscured these obligations, and at worst, has made them obsolete. Data collected by local ALPRs is stored in servers managed by these companies, and without any back-end system management, companies share this data with any other law enforcement agency that contracts with the company. Additionally, these companies grant themselves quite broad contractual exemptions in how they access and utilize the data to train their systems or develop their software. We think this bill, as amended, modernizes the ALPR statute to ensure that it's reflective of how these public-private ALPR agreements work, that there's public disclosure of who our agencies are sharing this data with and how frequently they're sharing that data, and that we have some public reporting of the private use of these systems. We urge the committee's support for this bill today. Thank you.
Thank you, Mr. Beeler. Just also, in terms of what's happening with this bill today, this is another bill that we will be laying over. Jeff Potts, I understand you would like to testify on this bill. Please, once you get settled, state your name for the record and go ahead with your testimony.
Madam Chair, thank you. Again, my name is Jeff Potts. I am the Executive Director for the Minnesota Chiefs of Police Association. I am here to testify on behalf of the Minnesota Chiefs of Police Association. That is roughly 300 police chiefs and hundreds of command staff members across the state. I am here today to share our concerns with Senate File 4739. Our concerns center on the data provisions in the bill. And just to clarify, LPR data, as we kind of describe it generically as LPR data, does not actually contain names, addresses, or what we otherwise consider personal information. However, what is retained essentially is a photograph of a license plate that is tagged with the date, time, and the geographic location of where that photograph was captured. The data is critical, that data is critical to solving crimes, which is why LPR technology is relied upon by so many police departments throughout Minnesota and frankly across the country as a crime-solving tool. I heard earlier in a previous bill, I think it was Senator Holstrom referenced the insane number of auto thefts in the state, and he is accurate. In 2024, there were 13,000 auto thefts. In 2023, there were 16,000 auto thefts. And I can tell you that ALPR is probably the #1 tool in at least recovering those auto thefts or those stolen vehicles here in Minnesota and frankly across the country. Our specific concerns are sections 2 and 4 of the bill. Section 2 designates the Bureau of Criminal Apprehension as the central repository for all license plate reader data. We believe this data is properly owned by the individual agencies that collect it. Beyond the question of ownership is the cost of building and maintaining a central repository will be substantial. We anticipate those costs would be passed directly on to the agencies that use the technology. And for many departments, particularly small ones who have just started to utilize license plate readers, those added expenses will make LPR very difficult and frankly in some cases impossible to sustain. Section 4, this is the reduction in LPR data retention. Section 4 reduces the permissible retention period for LPR data from 60 days, which is currently where it's at, to just 48 hours from the time of collection. And we believe this window is functionally inadequate for serious criminal investigations for 3 reasons. First, serious crimes take far longer than 48 hours to investigate. The average time for a first arrest is 33 days for rape cases, 19 days for murder cases, 24 days for human trafficking, and a 48-hour retention window would render the LPR data useless in the vast majority of those cases. Second, detectives often don't know what they need until later in the investigation. A lead uncovered 2 weeks into a murder case may require a plate data from the actual day of the crime, and if the data had already been deleted, so has the lead. Third, many crimes go unreported immediately. Victims of rape, trafficking, and assault frequently do not come forward for days or weeks. By the time an investigation is open, the 48-hour window will have long since expired. It's worth noting that crimes most dependent on LPR data are also the slowest to clear. Vehicle theft, human trafficking, and other cross-jurisdictional suspect tracking are exactly cases where plate reader data matters the most and where investigations typically run the longest. Madam Chair, we urge the committee to carefully weigh the impacts before advancing this bill as it's currently written. We oppose Senate File 4739 in its current form, but we remain committed to working with the bill's author to address the underlying privacy concerns and produce legislation that serves both the public safety and the communities that we are sworn to protect. Thank you, Madam Chair, for the opportunity to testify here today.
Thank you, Mr. Potts. And just as a clarification, Section 2 was removed by the amendment. I think you mentioned in your testimony that you are opposed to that, so that piece has been removed by the amendment.
Thank you. I have not had a chance to fully read the
That's okay.
the amendment,
I just wanted to reassure you that that's been taken out. Okay, I do not believe we have any other testifiers. Senator Holdenstrom.
Thank you, Madam Chair. Thank you for bringing this legislation forward, Senator. This is actually a hot topic. People are really concerned about LPRs and how they're used. And I'll say right away, I've heard of cases, atrocious things happening. In Kansas, there was law enforcement that used it to track down their exes and harassment, and that's absurd, and we should find a way to stop stuff like that. But they certainly have a place in our communities. Wright County, where I serve, where I live, we had our flock cameras go online, I think it was last month, and within hours, they were used to identify a burglary of a jewelry store and capture the individuals. So we need these. These are part of law enforcement every day, as discussed, auto thefts, and there's definitely a place for them, and there's definitely a place for regulation. I think getting the conversation started is something worth doing. I'm glad you removed Section 2. That was a concern of mine immediately. But I'd like to be part of this conversation moving forward, and as we bring in stakeholders, because I think that Liberty has certain requirements that we have to respect, but also our law enforcement need all the tools they can get at this time. So I appreciate this, and I look forward to where this bill goes.
Thank you, Senator. Any other questions or comments from members? Senator Pappas.
Yeah, Madam Chair, I am concerned about that Section 4 and the destruction of data required. I think that the 60 days was an original compromise, and it seems like quite a extreme change to 48 hours, just given the fact that it just takes a lot of time to go after these cases. So I would just, ask you to consider that down the road.
Senator Oumou Verbeten.
Yes, thank you, Madam Chair. Thank you, Senator Holmstrom, Senator Pappas. If you would be happy to work with you on the legislation. I wanted to just first share that I think one of the concerns we're seeing is some cities have gotten rid of this altogether because of the privacy concerns, and so there's kind of been this like all or nothing approach, and there are some very legitimate uses for ALPRs. We just want to make sure that private data remains private, that we have the important kind of restrictions, and that we're following the Minnesota Data Privacy Act here. I think we can be flexible on the destruction of data. To your point, Senator Pappas, the bill as introduced took the language that we see from the Minnesota State Patrol and their policy and destructing after 48 hours. But I do hear those situations where you may not know that you'll need that information for a criminal investigation until after 48 hours. So I think that's a timeline we're going to have to continue to have conversation about. But to be clear, this is around the destruction of data that is not active to a criminal investigation. I think what folks are speaking to is if you don't know that you'll need it for a criminal investigation, and if it's already been destroyed before you can make that determination. So I understand that. It's just that I want to be clear that language is specific to data that is not related to an active criminal investigation.
Senator Limmer.
Thank you, Madam Chair. Is anyone from the BCA or Department of Public Safety that would be willing to give testimony on this bill? Since we're revising some of the rules and processes of the department, I would think they would want to weigh in on this, or at least give us an assurance that they're in agreement.
Senator Limmer, I don't see anyone running to the microphone, but just as we are laying the bill over.
Okay.
And Madam Chair,
Senator Oumou Verbeten.
and just as a reminder too, the sections that did have the BCA creating kind of central repository have been removed through the A2 amendment.
Yeah, Madam Chair.
Senator Limmer.
On page 3, lines 30, starting on lines 31, automated license plate reader data may not be accessed, disseminated, or shared outside the state. And outside the state also includes federal agencies. Perhaps Senator Oumou Verbeten, could you tell me if the federal law enforcement is working in cooperation with a local police department or a VSAT team? Are they restricted in gaining this information as they are working with local law enforcement? The way this is written, it seems like that's the case.
Senator Oumou Verbeten.
Madam Chair, thank you, Senator Limmer, for the question. One of the pieces of the amendment that was adopted was just to ensure that when it is shared with a separate law enforcement agency, there's a written data sharing agreement. And so I believe it would fall under that. I think the intention is to really limit who has access to that ALPR data unless, you know, there is a warrant or there is a written agreement between agencies to share that information. What we're seeing, because of kind of how broad the companies, the broad access to information the companies have, anyone who's sort of working with them has access to data across the country. And so we're really trying to limit that so that as people decide to purchase ALPR data and work with these companies, if they're going to share that outside of the agency that is using it, they're either getting a written agreement or they're following the process to get a judicial warrant to access that information.
Okay. I guess the question I have is, and knowing that things can sometimes change rather quickly out in the field, and if there was a partnership pursuing an investigation and a license plate reader process was required, things happen pretty fast out in the field, and I'm not quite sure that this would allow that if you have to go back somewhere and review written agreements, write written agreements, narrow the written agreements, then find the authorized person to sign the agreements. We certainly do not want to put the public at any other risk of their safety if there's some big bureaucratic process in order to just share in a very isolated case license plate data. So I'm very concerned about this particular restriction, and perhaps it can be rewritten to accommodate a federal agency when they're actually out in the field or working an active investigation. And I know we're laying it over, but it's food for thought, and perhaps we can talk about that at another time. Oh, one other question, Madam Chair. Council, could you weigh in on this? Is there, or could you explain the process that Senator Oumou Verbeten suggested about the written agreements in light of a criminal investigation? Is that written into law somewhere?
Ms. Primo.
Mr. Chair and members, line 3.31 of the bill says, notwithstanding any other provision in this section. So the way I would read all these provisions together is that paragraph D would supersede the other provisions that are in 13.824, and therefore it's possible that at least one interpretation is that the data could not be released even pursuant to that written data sharing agreement because of the way paragraph D is drafted. And so it, depending on the goal and intent of the author, we just may want to clarify that a little bit further.
Senator Limmer.
Madam Chair, since we're going to lay this bill over, I think we'll have to work on it a little bit before it comes back to the committee.
Okay.
Thank you.
Any other comments or questions? Seeing none, Senator Oumou Verbeten, any other final remarks?
No, I just appreciate the conversation. Thank you, Madam Chair.
Thank you. And this bill, Senate File 4739, is laid over. We will next be taking up Senate File 4667, Senator Seeberger. Senator Seeberger, I understand you have an A2 amendment. Would you like to address that now?
Yes, please, Madam Chair. I would offer the A2 amendment as an author's amendment.
Okay, this is the first stop for this bill. Senator Seeberger offers the A2 amendment. All those in favor say aye.
Aye.
Opposed? The A2 amendment is adopted. Senator Seeberger, to you, bill.
Thank you, Madam Chair and members of the committee. I am delighted to be here on Senate File 4667 as amended. This bill deals with the eligibility of a person for survivor benefits relating to specific exposure-related cancers prevalent among firefighters. This is an issue that has been worked on for several years. For the last 2 years, Senator Jeff Howe has worked with the Department of Public Safety to address cases where firefighters succumb to COVID-related illnesses and certain other viruses and infectious diseases. At the same time, Senator Howe was attempting to expand the list of covered illnesses. The Minnesota professional firefighters were pushing for an expansion of work-related cancers for firefighters. The Department of Public Safety was also wrestling with a statutory provision that did not provide a definitive definition for the types of line-of-duty deaths that occur. Last year's work on the bill was laid over. In the meantime, Senator Amy Klobuchar and Senator Ken Kramer of North Dakota worked to pass the Fallen Heroes Act, which included a list of cancers which are related to the occupation of firefighting. That law passed on December 18th, 2025, when President Trump signed the bill. As introduced, my bill followed the federal legislation. After the bill was introduced, the Department of Public Safety convened a work group that consisted of representatives from the Minnesota Professional Firefighters, the Minnesota Fire Chiefs Association, the Minnesota Fire Department Association, and MinFire. That group worked together to address all these various concerns, including those of the Department of Public Safety. The A2 amendment is the product of those efforts, and I'll walk through what this bill does. Sections 1 and 2 of the bill cover the exposure-related cancers that were addressed in the federal legislation and make those eligible for the Minnesota Killed in the Line of Duty benefits. Section 3 of the bill provides a major change in the law on page 2, line 6. This change will limit the benefits to only those types of injuries that are specifically referred to in the statute. This is done by adding the word expressly at 2.6. Section 3 also addresses the issues that Senator Howe raised last year. This is done from 3.1 to 3.6 that references infectious disease, viruses, and bacteria. In addition, 3.7 to 3.21 cover the standards for deaths due to exposure-related cancers. Sections 4, 5, 6, and 8 are sections DPS wanted included that use language from the Federal Public Safety Officer Benefit Law regarding the definition of non-routine, strenuous physical activity, and routine physical activity. This language mirrors the federal legislation and should bring clarity to the process and less litigation. And Section 9 deals with exposure-related cancer going back to January 1st, 2020. The A2 amendment, which we adopted, does not include language in the original underlying Senate File 4667 relating to requiring rulemaking by the DPS for other types of cancer that could be included or covered under the statute in the future. The parties decided it would be best if there were additional types of cancers or other causes of death that merit coverage, that we should bring these before the legislature rather than having DPS deal with it through rules as the federal legislation requires. With the deletion of the rulemaking authority in the A2 amendment, we believe we have eliminated any fiscal note to the bill, as that is primarily what was being addressed in the fiscal note that we received on the underlying bill. In fact, there may be some savings because by limiting the claims to what it is expressly put into statute, it should reduce litigation. In addition to being good policy, this legislation will align state law with federal law. So if a public safety officer dies on the line of duty and is eligible for the federal benefit, there should be no reason they also would not be eligible for the state benefit. In fact, as a further reason, this is good policy. It's because you cannot apply for the federal benefit until you receive the prerequisite certification for a state line of duty death benefit. Given the work of the DPS, the Fire Service, and Senator Howe, and their ongoing work on this bill for a number of years, this is a very solid approach on how to recognize public safety officers who are killed in the line of duty. I also want to take a moment to once again acknowledge Senator Howe. He couldn't be here. I had offered to have him co-present this bill with me, given his work and his dedication to this issue for a number of years. But as we often do, and on our Fridays, he picked up a work shift, so he is unable to be here. But I did want to publicly acknowledge his work, and I am pleased to be able to present this to you. I would like to turn it over to my testifiers. I have Julie Pater and Jim Chandler, who can also speak to their personal experiences.
Thank you, Senator. I appreciate that. Ms. Pater, would you like to identify yourself for the record and go ahead with your testimony?
Hi. Good morning, Madam Chair and the members of the committee. My name is Julie Pater, and my husband was a firefighter for St. Paul Fire Department and Maple Grove Fire Department. I stand before you today to express my strong support for SF 4667. Occupational cancer is a devastating reality faced by our brave firefighters and their families. Each day, these individuals selflessly put their lives on the line to protect our communities, and they deserve recognition and support that reflects the sacrifices they make. Just like those who suffer injuries in the line of duty, families dealing with the aftermath of occupational cancer experience profound loss and grief. Their lives are forever altered, and they should not have to battle an inefficient system to receive the acknowledgement and assistance they rightfully deserve. Minnesota's acknowledgement of line of duty deaths is vital. When the state recognized that my husband Mike lost his life to cancer, which he contracted while serving as a firefighter, it was a moment filled with both sorrow and pride. That determination affirmed that his service did matter to this state. It honored his sacrifices and promised us that he would not be forgotten. Cancer is the most common cause of firefighter line of duty death, but to date, Mike is the only firefighter who has been ruled eligible for the State Public Safety Officer Benefits Program. For over 5 years, my family has advocated for changes to the BSOB system, both at the state and the federal levels, to ensure that occupational cancer is recognized in the same way as other line of duty deaths and injuries. Our experiences navigating this complex system have revealed the immense challenges grieving families face. But I believe that no family should have to endure administrative red tape and meet a burden of proof, all while mourning their loved one. The state's acknowledgement of cancer as a line of duty death can't be on a case-by-case basis. It must be presumptive. SF 4667 is an important step in addressing these issues. It not only aims to provide justice for those who have fallen victim to occupational cancer, but it also is going to be able to ensure that the families receive the necessary support without further struggle. We urge you to consider the sacrifices made by our firefighters and their families and to support SF 4667 for a fair and compassionate recognition of their service and struggles. This bill mirrors the federal legislation passed in December, and it would ensure that surviving family members receive protection from both the state and the federal governments. Thank you for the opportunity to speak today and for your commitment to supporting our valued first responders and their families. We know firsthand the challenges and the burdens that families face after such a loss, and we will return every year it is necessary to ensure that no grieving family must navigate unnecessary barriers to receive the recognition and support their loved one has rightfully earned. Thank you.
Thank you, Ms. Pater. I'm so sorry for your loss, but I do appreciate you coming here today to share your testimony with us. Thank you. Senator, I'm sorry, I got your first name, sir. What is your last name?
My name is Jim Chandler.
Great. Go ahead with your testimony. Thank you for being here.
Thank you. Thank you, Madam Chair and members of the committee. Like I said, my name is Jim Chandler. I'm a member of the Executive Board of St. Paul Firefighters Local 21. We represent the 475 professional firefighters, paramedics, and emergency medical technicians right here in St. Paul. Additionally, I'm here to speak on behalf of all firefighters in the state of Minnesota amongst the strong support of Senate File 4667. Lastly, I'm also here to speak amongst myself that I'm a father of 2 young children. My family and I live right here in St. Paul, and I'm a survivor myself of occupational cancer, my 13 years of exposure as a St. Paul firefighter. This bill addresses the gap in how we recognize line of duty deaths, one that no longer reflects the realities of our job as firefighters. For decades, we have understood firefighting as dangerous work. When a firefighter is killed in a structure fire or dies from a traumatic injury on a call, there's no question. They died in the line of duty and their families are supported accordingly. But today, the greatest threat to firefighters is often not always immediate or visible. Cancer is now the leading cause of line of duty deaths of firefighters in the United States. In 2022, the International Agency for Research on Cancer classified firefighting as a Group 1 carcinogen, the only job in the world that stands alone with sufficient evidence that our occupation in and itself causes cancer. And we understand why. As firefighters, we are routinely exposed to carcinogens like benzene, formaldehyde, heavy metals, and PFAS. Through inhalation, smoke, or skin absorption, and even from our contaminated fire gear. These exposures don't happen once. They happen repeatedly across thousands of incidents over the course of a career. It is not a single event risk. It is cumulative, and it builds up over time. At this point, the connection between firefighting and cancer is no longer theoretical. It is supported by a substantial body of scientific and medical evidence to a reasonable degree of medical certainty. Minnesota has already taken the important steps to recognize this reality in certain cases. And in December last year, the federal government also followed suit with the passage of the Honoring Our Fallen Heroes Act, extending federal PSOB benefits to families of firefighters who die from service-related cancers. Senate File 4667 simply brings Minnesota into alignment with that federal standard. This alignment matters. When both the medical community and the federal government have moved in the same direction, it creates a clear signal for state policy to follow, grounded in evidence, not assumption. At its core, this bill is about consistency and fairness. Right now, 2 families can experience the same loss. Both could lose a firefighter to occupational cancer and receive entirely different recognition and support, depending on how that loss is categorized or adjudicated. This creates uncertainty at the worst possible time for our firefighters' families, when they are grieving and trying to rebuild their lives. This bill would remove that uncertainty. It establishes a clear, presumptive standard that reflects what we already know. The repeated occupation exposure in the fire service creates a real and significant cancer risk, and that when that risk results in a death, it should be recognized as a line of duty sacrifice. It also reduces the burdens on our firefighters' families. No surviving spouse or children should have to navigate years of administrative process, gather medical documentation, or prove causation, while also mourning the loss of their loved ones. We do not ask that of firefighters when a firefighter dies. We don't ask that of their families when a firefighter dies in the fire ground. Why would we ask it here? It's important to recognize that even the data we rely on likely underestimates the risk that our firefighters face. Many occupational cancers are difficult to study, often underreported, and historically misclassified. That uncertainty is exactly why presumptive policies exist, because the burden should fall not on grieving families to prove that what science already strongly supports. It is not about expanding benefits beyond reason. It's about aligning our current policies with modern science, existing federal law, and the realities of our profession. Every firefighter understands that this job comes with a risk when we raise our hands and we take an oath to put our life up for collateral to save another's. Our families accept this risk as well. But accepting this risk does not accept inconsistency, or uncertainty with how our sacrifice will be recognized. If we are willing to call it a line of duty death when it happens in a moment, we should be willing to call it a line of duty death when it happens over time. Senate File 4667 would do exactly that. Thank you very much for your consideration. You're helping recognize our firefighters and my sacrifice and making sure our families are not left behind. And we respectfully ask for your support in this.
Thank you, Mr. Chandler. First of all, thank you for your service, and also I just wish you many years of good health in the future.
Thank you.
I'm sorry for the experience that you've had. Wish you the very best.
Thank you.
Any comments or questions for Senator Seeberger or the testifiers? I do not see any. Senator Seeberger, would you offer some closing remarks?
Thank you, Madam Chair. It is beyond time that we recognize the exposure-related line of duty deaths that occur in the fire service. Years ago, it used to be a mark of pride. If you were an old-timer in the fire department, you wore your turnout gear covered in soot, never washed it. It was, that was the way you did it. The dirtier the gear, the more kind of prestige that you had. But now we know that all of that soot, all of the layers of whatever is on your turnout gear gives you cancer. Everything in the fire ground is a carcinogen. Everything even in our turnout gear, the PFAS that's contained in our turnout gear gives you cancer. This is a dangerous job, and I'm grateful to be here so that we can finally recognize and give our fallen firefighters and their families the benefits that they are due.
Thank you, Senator Seeberger. And my understanding is we're going to be moving this to the Finance Committee.
Yes,
Senator Seeberger would like to move that Senate File 4667 as amended be recommended to pass and referred to the Finance Committee. All those in favor say aye. Aye. Opposed? Very good. All of you guys. Very good. Excellent. Senate File 4667 is sent to Finance. Yep. Senator Dibble, you are up next. As you are coming to the table, we are now going to hear Senate File 4377. Senator Dibble, and my understanding is this bill will also be laid over. Senator Dibble, is that your understanding that we will be?
There is a blank appropriation. I think we need to move it to finance.
Finance, okay. Very good. Senator Dibble, to your bill.
Thank you, Madam Chair and members, for the opportunity to present Senate File number 4377. Madam Chair and members, this bill is about a very practical solution to a problem that has been identified with respect to transit, particularly in the urban areas, particularly as we're starting to implement more and more bus rapid transit with dedicated lanes and the like, and also, of course, the ongoing issue that we have sometimes at bus stops. So very quickly, I'll do a quick overview, and if the committee so desires, I can do a more specific walkthrough of the bill itself. So the bill would authorize transit agencies to use transit obstruction camera systems mounted on transit vehicles, buses, to identify violations where vehicles block bus stop zones, obstruct bus-only lanes, or interfere with bike lanes during transit operating hours. The way they do that is they automatically detect and record potential violations, capture limited video or images of the vehicle and license plate, and then allow a trained parking enforcement agent to review and verify before any citation is issued. So there is human oversight. Every citation is reviewed. The bill is structured to be fair, transparent. There is an initial warning period of at least 60 days before this program would go into effect. Citations are issued by mail after they're reviewed. The violations are petty misdemeanors only. They don't impact a driver's license status. And there are exceptions provided for emergency situations, legal stopping circumstances, medical emergencies, and the like. Importantly, you cannot be cited twice for the same incident under different laws. And there are strong privacy protections. The data is classified as private or non-public. There's no facial recognition or biometric technology allowed. Data can only be used for transit enforcement purposes. It has to be deleted within 30 days unless tied to a violation. There are strict limits on sharing and retention, and there are required audits of any private vendor. With respect to vendors, the bill allows transit agencies to partner with a private vendor, but with clear limits. There are no contracts that would be allowed based on the number of tickets issued. I mentioned the audits that are required, and of course, full compliance with our data laws. The reason for this bill, very quickly, blocking transit is a big problem. It's not just an inconvenience. It creates slower, less reliable transit service. It represents safety risks for riders who are boarding in traffic, reduces accessibility for people with disabilities, conflicts with cyclists and other road users. And it is a resource issue. It allows for law enforcement to focus on what they should be focusing on. They obviously can't be everywhere at once. So it's a low-cost, high-impact tool to support compliance. It's been successful in other places where it's been implemented with 40% reduction in bus stop violations, fewer collisions. It is also preventative, changes behavior very quickly. Those are similar results in a number of cities. It is in the context, of course, of our having already established school bus stop arm cameras, the traffic safety camera pilot programs that are occurring right now, and work zone safety cameras as well. That's another pilot that's happening right now. It requires coordination with local governments, the Department of Transportation and Public Safety, and public education before it is rolled out. It's supported by the City of Minneapolis and a number of industry experts and transit partners who provided a great deal of input. So that's the bill overview. Madam Chair, I can walk through the bill quickly if you like. All right, so very quickly, Section 1 establishes some data practices by a new subdivision under 13.6905 to ensure that data collected by transit, these cameras, is governed by the specific provisions created in this bill and ensures a clear classification and handling of that data under our framework. Section 2, also on page 1, provides that these are not ALPRs, automated license plate readers, to prevent confusion in that regard. Section 3 creates some limitations, and you can find Section 3 starting on page 2. And that places some limitations that they cannot be used under ALPR authority, reinforces that distinct legal framework and safeguards. Section 4 on page 2 defines the system as cameras and related technology used to capture images of vehicles violating parking and stopping laws, to include image capture, storage, retrieval, and transmission capabilities. Section 5 on page 2 allows local governments to regulate parking and stopping violations through this mechanism and confirms that it is within local police powers over traffic and parking regulations. Section 6 on page 3 provides some definitions to key terms: public transportation, the transit operator, the Met Council, other providers, a transit vehicle. So I'll just say that Section 6 is comprised of a number of subdivisions, 13 of them, so I'll just go through those very quickly. So moving to subdivision 2, page 4, is the authority and implementation that authorizes transit operators to install and use the camera systems in coordination with local governments, MnDOT, and DPS, in compliance with system standards. Subdivision 3 on page 4 allows systems to detect and record potential violations automatically and requires the state to establish technical standards towards the end of this year regarding camera placement, data collection requirements. Subdivision 4 on page 4 requires that there be public-facing information on websites, identification of the routes that are using the cameras, instructions on how to contest citations, and mandates a public education campaign prior to implementation. Subdivision 5 on page 5 establishes the violations as a petty misdemeanor for blocking bus stops, bus lanes, bike lanes, and it only applies when the violation is captured by the camera system. Subdivision 7 on page 5 provides protections. There's no violation in the case of emergency conditions, legal stopping when that's permitted, or medical emergency, and prevents double citation for the same conduct. And clarifies that there are no driver's license consequences. Subdivision 8 on page 6, that's the citations and warnings. There's an initial warning period before citations would begin, so this is similar to what we did with the speeding camera. We had a long period of time the public be notified that this was going to be happening at some point in the near future. It provides for the human review before citation can be issued, and it allows citations to be issued by mail within defined timelines. Subdivision 9 on page 6 requires a standardized statewide citation format to include violation details, time, location, and vehicle, the image evidence, the statement that it has been reviewed by an enforcement agent, and how to contest the citation. Subdivision 10 on page 7 discusses the third-party agreements to allow the contracts with private vendors for equipment service operation, prohibiting the payment based on the number of citations or violations, and requires the audits. Subdivision 11 on page 7 classifies the data as private or non-public, limited only for this purpose, restricts sharing only with transit or local government or by court order, and prohibits use in unrelated legal proceedings. Subdivision 12 on page 8 limits collections only to the license plate image, the vehicle context necessary to identify the violation, and non-identifiable system data, prohibits facial recognition or biometric identification, requires no identification of individuals, and the data be retained only when a violation is detected. Subdivision 13, more on data retention and destruction to be deleted within 30 days unless tied to a violation, allows retention for active cases or exculpatory evidence, requires final deletion within 3 years after a case has been resolved, and includes special protection for program participants specific to address confidentiality. Section 7 on page 9 amends 169.99 to include transit obstruction citations in the uniform ticket system and to ensure consistency with other traffic violations. And then Section 8 is the appropriations section, and that appropriation will be directed to MnDOT. That's my bill. We do have a testifier, Madam Chair. I'm able to pause for questions, or we can go to testimony, whatever is your pleasure.
Thank you, Senator Dibble. Let's go to testifier, and I understand we have Ann Shikani, and I'm sorry if I'm pronouncing your name incorrectly.
It's Shikani, but thank you.
Shikani, I'm so sorry. Go ahead and identify yourself for the record and proceed with your testimony.
Hi, I'm Ann Shikani, Director of Legislative and Regulatory Affairs at Haven AI. I'm pleased to be with you here. Thank you to the chair, the vice chair, ranking member, and all the members of the Judiciary Committee. I'm sorry I can't be there in person, but I'm glad to be with you virtually. I'm here to support Senate File 4377, which would provide Metro Transit with the authorization for vehicle-mounted automated parking enforcement of bus stop zones, bus lanes, and bike lanes. And if possible, I'm going to share the presentation that you all should have in your files today. Can you see this?
Yes, go ahead.
Okay. As I mentioned, this new authority will improve access and reliability for transit riders across Metro Transit service area. And it's especially important for seniors and disabled Minnesotans. It would also protect the investment Minnesota's made in its BRT system. Vehicle-mounted automated parking enforcement systems are cameras and computers that are inside the bus. They monitor the roadway for parking violations. And this system can automatically detect potential violations, captures a short video and still images that are packaged for parking enforcement agents to review, and they ultimately decide if a citation will be issued. This has been seen as a best practice, and we have active programs across the country. Some are in large districts, some are in smaller. Some of the longest programs have been in New York City and Washington, D.C., and I'll share some outcomes from those programs. This has also been very successful in kind of medium markets that are more similar to Minnesota, including Sacramento. And I'm going to skip forward, since this is the Judiciary Committee, to some of the data privacy protections that are included in the bill. So, and just inherent in this kind of technology. The bill itself conforms to existing Minnesota data privacy requirements for your safety cameras. It also bans the use of biometric tools such as facial recognition. And the evidence can only be used for parking and transit purposes. It can't be used for other law enforcement. It's really targeted photo and video evidence. The technology only captures a short video of a few seconds, and that other footage is then deleted off the bus. It never leaves the bus. There are strict data retention and destruction requirements, and as I mentioned before, it does require the final review by a human parking enforcement agent before any citation is issued. And I'll go back. Some of the positive outcomes we've seen for this kind of technology really are disability access to transit and the reduction of safety issues during boarding. If a blocked bus stop, it's more than a nuisance for disabled transit riders. It's a real safety issue. When the bus can't deploy its ramp, wheelchair users are required to move into the moving traffic lane to board the bus, and sometimes they're not able to board at all, which can be the difference between getting to your destination at all. And some of the other positive benefits we've seen, as I mentioned in New York, we've seen increased bus speeds, we've seen a 40% reduction in bus stop violations, fewer collisions up to 20%, and most violators only get one ticket. 91% of folks in New York have only received one ticket, which really shows that this technology effectively changes driver behavior. And the program in Washington, D.C. is called Clear Lanes. It began in late 2023. They've also seen faster buses while traffic outside of the kind of Clear Lanes routes has fallen, which means faster traffic for everyone, which is great. We've seen decreased violations there as well, 41 for bus lanes and 30% for bus stops. And really positive disability access benefits with a 10% increase in wheelchair ramp deployments. Over 1,000 times per day on those Clear Lanes routes. And I'm happy to take any questions.
Thank you so much for your testimony. I don't believe we have any other testifiers, is that correct?
Correct.
I will open this up for member questions. Senator Limmer.
Thank you, Madam Chair. Senator Dibble, I don't particularly have any problem with your bill, but I did have a question about the video only capturing 10 seconds of data. I'm a little concerned that in some cases may not give adequate context to certain images. Could you tell me how you arrived at the 10-second mark?
Senator Dibble.
Thank you, Madam Chair. I think Senator Limmer, I'm just going to guess and then I'll ask Ms. Shikani to see if I got it right. I think this is, the practice that's been established and been successful in other cities. I think it's 10 seconds versus just a snapshot, just to give a little bit of context of exactly where the vehicle is, and the fact that it's, situated, inappropriately in a bus lane. For example, we have, for example, near where I live near Hennepin Avenue in the uptown area of Minneapolis, and the Hennepin Avenue is 2 lanes, except for during rush hour, northbound and southbound for a couple of hours on either side of the day. It's just exclusively for the bus unless you're moving into the lane to take a right. Sure enough, every so often there's a car just parked in the bus lane during rush hour, which causes a huge hassle, not just for the bus, and the bus riders, but that bus then needs to stop and then make its way into the regular lane, and so then it just blocks everything. So I think it's just designed to give a little bit of context, around that particular car. Let's see if I got that right. Can Ms. Shikani maybe help round out the response?
Ms. Shikani.
Senator Dibble, that was very accurate. I would say this is for parking violations. So 10 seconds, we've
found as an industry best practice is more than enough time. The bus generally passes the parked vehicle in these evidence packages, so you see that it is in fact parked. It is possible to see people disembarking or loading or unloading, and that can be in extenuating circumstances. In some case, that is captured on the video and generally provides the context needed for the reviewer. If they're moving violations, then it can be a longer video, and we can set that up with the agency, but that is not what this bill is related to. These are parking violations only.
Senator Limmer?
Ms. Shinkari, in the event that a person was picking up a pedestrian on the side of the curb, is that a violation in this case? Would a person get ticketed?
Ms. Shikani?
I would have to look at local law. There can be exemptions for loading and unloading, and as we said, there's human review for these violations. So if the parking enforcement officer thinks that it is a reasonable use, then a ticket, is at their discretion. But I would have to review the local law, and I think it depends on the situation. A bus stop may be different than a bus lane, so it probably depends on what the violation is.
And Madam Chair?
Senator Limmer?
Thank you. How long is the video retained?
Senator Dibble or Ms. Shikani?
Thank you, Madam Chair. Senator Limmer. It's retained if it's determined there's no violation. I believe it's deleted immediately or practically immediately. If it is retained, it's kept for some period of time. I have to go back to my notes, until the matter is resolved, and then it's deleted. And in any case, it's deleted. Let's see, there's a deletion, here we are, subdivision 13, which is on page 9 or 10 or 8. Hang on one sec here. So subdivision 13, data practices and destruction of data. Says, except as otherwise provided, data collected by a transit obstruction camera system must be destroyed within 30 days of the date of collection unless it's subject to criminal investigation data related to a parking violation. And then there are some other, purposes for retaining the data, if it's going to be used as exculpatory evidence, et cetera. So
typically within, a short period of time. Madam Chair, I'm just concerned about due process for someone that would face a violation, and if they wanted to challenge the accusation, is 30 days enough to retain that so that perhaps they could use that video for their own defense? I don't know how fast the court will catch up to the owner of the vehicle. And then in response, how long does it take for in this case, a defendant would want to challenge the accusation? So I'm just concerned about the due process and the 30 days, if that's enough.
Thanks. Senator Limmer, and I don't know, counsel may be able to back me up here, but I believe if you look at paragraph B, it states that it does have to be preserved until the charge or complaint is resolved or dismissed. And so it seems to me that if there's something pending, they have to keep it. That's my understanding. But we can, Senator Limmer.
Madam Chair, I'm just concerned that we're maybe writing a conflict into the law. If there's a reference on removing the video or destroying the video within 30 days, is that in conflict with holding the video until the matter is resolved in a court? That's all.
Senator.
Madam Chair, I believe the short answer to Senator Limmer's question is no. It's destroyed within 30 days. unless it's the subject of a criminal investigation related to a parking violation. And then, as Chair Westland just called our attention to, if you look at line 8.2, starting on line 8.28, paragraph B, whoever is subject to a pending criminal charge or complaint says that the data must be preserved until the charge or complaint is resolved or dismissed. So, but I'll turn to Ms. Primo to see if we've gotten it right or not.
Ms. Primo?
Madam Chair and members, yes, that's how I interpret how the various paragraphs under subdivision 13 work together. So the 30-day deletion applies only when there's not a parking violation involved. Otherwise, paragraph B applies, and then there's also other destruction and retention provisions in paragraph C and D and E as well.
Okay, I think I have Senator Clark.
Thank you, Chair Westland. Thank you, Senator Dibble. Just a quick question on recidivism and repeat offenses. So in Ms. Shikani's testimony, she was discussing the fact that I think in New York City, 91% of violators receive only one ticket. Effectively, the technology changes driver behavior. And this may be a question for you, Senator Dibble and Ms. Shikani. Is that sort of common, and do we see similar results elsewhere, that you're basically one and done?
Ms. Shikani or Senator Dibble?
Madam Chair, in my notes, there's a similar experience in Washington, D.C., where I think there's a great reduction in violations from the outset. So it's got to our discussion of a few days ago, the preventative aspects of putting this rule and the accountability for this rule in place. And should someone be dinged for such behavior, they tend not to do it again. And I think that's actually replicated in cities beyond just those two. Ms. Shikani can help us maybe round out the response.
Again, Senator, you got it correct.
Ms. Shikani.
That is very common. We see a decrease in violations and also a very low recidivism rate. I don't have the exact statistics for some of the other cities that have this program going, but they are very high numbers of single offenses.
Senator Clark. Okay. Any further discussion on the bill? Senator Latz.
Thank you, Madam Chair. Just emphasize the point that part of the value of deterrence, probably the most important piece of deterrence in our criminal justice system, is the likelihood of getting caught. So if people think they can get away with stuff, especially things that might be more minor, but even more generally, they're more likely to try. If they think they're more likely to get caught, they're less likely to try. This kind of system increases the likelihood of getting caught, so it brings them into conformity with established standards of behavior.
Thank you, Senator Latz. Senator Holmstrom.
Thank you, Madam Chair. And to that point for Senator Latz, I think that is even more reason that Minneapolis should focus on getting more police officers on the streets so we have more ability to catch these criminals. Now, to the people parking in bike lanes. I have a question for Ms. Shikani. What did you, I don't know if you've tracked this, but like in New York and DC, what was the increase in the amount of tickets issued after this went into effect?
Ms. Shikani.
I don't have that specific statistic, but we can get that information for you. I do know that ticketing generally increases significantly through these programs in the beginning and then declines over time.
Senator Holmstrom.
Thank you, Madam Chair. I also have a question. I noticed the ACLU is still in this room, and earlier today we heard a bill about ALPRs, and this seems to be similar technology. I don't know if they might have insight or if they wrote a letter on this that didn't make it to us. I'm not sure, but it seems like they might have something valuable to add to this conversation.
I don't believe anyone else has asked to speak to the bill. Mayor Holmstrom.
Fair enough. I'll note that there's a disconnect there then for me. But so my concern with the bill is that on the obvious scope, someone might end up getting a ticket that they weren't driving the vehicle and have no ability to defend that adequately. It's also that I don't, well, I'll ask this. This legislature chose to get rid of red light cameras, I think in 2009. Can you explain how this is different than the technology being used in red light cameras and why it should be preferred or be a preferred use when we don't with red light cams?
Senator Dibble.
Thank you, Madam Chair. What happened with the history of the red light cameras is Minneapolis instituted the red light camera enforcement program without the authorization of state law. And so the courts found that they were in violation. They needed an affirmative permission to do so. And so fast forward to a couple of years ago, that enacting authority was actually provided. So Minneapolis and Mendota Heights and others are now allowed to. They're not doing so quite yet, but I think later this year there will be a pilot in place to reestablish red light camera enforcement. We do have speeding enforcement through cameras. We also have a pilot for work zone violations enforcement, although it's pilot without any enforcements, but just warnings and the like, just to experiment with the technology for the purpose of keeping workers safe in highway construction project zones. And additionally, we have the school bus stop arm camera enforcement that is up and running and has some beneficial effect in, in sending a signal to folks that they're likely to be caught if they violate, the extended bus stop arm, and/or if they do so violate, they'll receive in that case, a very, very serious violation. And there are provisions in place for contesting those tickets if someone can say that they weren't actually the driver, even though they're the owner of the vehicle, they're the driver. I think we've tried to create some accommodation and some provision. There's an opportunity to contest a ticket here, but keep in mind this is a parking violation, and I don't know that would actually cause a ticket to be dismissed. If you get a parking ticket, I don't think you have the opportunity to contest a parking violation to say I didn't park the car there. You still, as the owner, still retains some responsibility. I might be wrong, but my understanding, moving violations are one thing, but parking tickets are another. And if your car gets a parking ticket, you can go down and to the Violations Bureau and contest it, say I did not park it there, and I think the Violations Bureau agent will say, it's your car, pay your ticket. So it's a slightly different conversation. But we do have, like I said, for those moving violations types of issues, speeding, stoplights, school bus arms, we have the opportunity for folks to contest based on that argument that they weren't the one driving.
And my understanding from council is that most of these are like petty misdemeanors unless, Senator Hallstrom.
Thank you, Madam Chair. The other areas that this was implemented in DC and New York, they have a much higher usage of their public transportation, of buses, and they have very little utilization of vehicles. In DC, it's about 50% of people traveling are doing some personal vehicles. New York is 30. In Minneapolis and St. Paul, and Minneapolis specifically, it's 80%. So there's a question about how much this is going to prejudice the average person. And I think it's because there's so many people using it, I think we're going to see a lot more tickets issued. And to your point, there's not a good way to defend against that. I would prefer that we continue to invest in people on the ground to do this work and not offload it to cameras that I'd prefer to see more parking enforcement and not this type of technology. So that's my 2 cents. I appreciate you. Thank you.
Thank you.
Right.
I respect that perspective. Thank you.
Any other questions, comments? Senator Koran.
Thank you, Madam Chair. Do you see this as opening the door to surveillance tickets, parking tickets beyond transit routes. It seems like once you kind of open this door, there's really no regulating factor why we couldn't use this technology for parking tickets all over. What are your thoughts on that?
Senator Dibble.
I understand that concern. Senator Limmer and I have joined, we are often holding press conferences together on all kinds of things. And one of them that we've joined on in the past is, mass surveillance and using those sorts of extraordinary coercive power, police powers of government in the state. And I don't see this as necessarily the camel's nose or the slippery slope or whatever metaphor, because I think there's a kind of a secondary concern, and that is, parking is one thing. Parking violations are one thing, but when a parking violation is actually inhibiting, citizens and workers from getting to where they need to go in a fair and efficient way, kind of consigning them as second-class citizens, I think that's kind of the clear, bright line distinction here. Just because someone's parking outside the proper hours and are not paying, what they should be paying to the city because the city charges for parking at that, that's a order of magnitude less important to me than allowing people to get on with their daily life through transit and just making sure that transit is getting the kind of mobility that people who use transit deserve, just like everyone else deserves.
Senator Koran.
Thank you, Madam Chair, and thank you for that response. I mean, I am a little concerned about this opening the door. I mean, most of traffic parking enforcement is done by non-sworn officers, traffic control agents, and one obvious option would be just to hire more of them. Now, of course, that's going to come with a cost. I'm sure that would be more expensive than this proposal to hire people to go patrol along these transit routes. Well, we had an interesting conversation earlier this morning, I don't believe you were here for, but about fines in general, and there was a bill that would prohibit fines for minors for misdemeanors, gross misdemeanors, felonies, any kind of delinquency. So what do you think, we heard all about how fines are a hardship and unfair to minors. Would your bill apply to minors who illegally park in a transit route?
Senator Dibble.
I'd have to think about that. Don't want to get dragged into that hearing. By the way, that bill had some implications for transportation, and had it moved on, I would have had to grapple with it because it would come to my committee.
All right. I think we've exhausted the conversation, and this bill stands between y'all and me cutting cake in the background, so I'm just saying. Senator Pappas.
Madam Chair, if we're ready for a motion.
I was just going to make the motion and call on you to do so.
You can't make the motion, you're the chair.
I was just saying we are at the point of doing that, and I was going to call on you to make the motion. Is that what you are?
That's what I'm referring to.
Okay. Senator Pappas moves that Senate File 4377 be recommended to pass and referred to the Finance Committee. All those in favor say aye. Aye. Opposed?
No.
All right. The motion passes.
Thank you, Madam Chair and members.
I will be handing the gavel back to Senator Latz. And cutting cake, and I'm sorry I did not bring enough for the whole class.
All right, next item up is Senate File 4196, Senate Report. who is appearing online. Welcome to the committee, Senate report. There is an A14 amendment, but this is the second committee, so it's a delete everything amendment. Senator Report, I'll ask you to walk us through the bill and the amendment, and then we can move from there. Senator
Thank you, Mr. Chair. I appreciate this committee hearing this bill again. What is in front of you today with the amendment has incorporated all of the feedback from the last hearing. Penalties have been reduced, the scope has been narrowed, and volunteer treasurers have been clearly protected. Even in cases for low-dollar willful violations where the board is newly required to impose a penalty, they retain discretion as to how much to charge. And basing enhanced penalties on percentages or multipliers means that they're proportionate. We removed existing penalties, including language related to circumvention, violations requiring or regarding unregistered associations, violations related to non-compliant IEs, and others. This bill is now focused on penalties when and where they matter most. Willful large violations and late reports containing high dollar amounts at critical times. It's been slimmed down to focus on the campaign finance late fees and civil penalties for the most egregious violations and the most time-sensitive reports. We've reworked the sections that remain to ensure that the legal standard applied is consistent and that larger penalties are appropriately targeted. Given these changes, it is a DE amendment. In summary, here is what it does. There are 4 sections that now only apply to violations that are willful and further distinguishes between small and large violations. Those are filing reports with false or incomplete information, failure to keep related records, failure to correct reports, and failing to cooperate with the board to reconcile a discrepancy. It does provide the board with discretion as to the penalty applied for violations up to $25,000. For violations over that threshold, the board must impose a penalty of 4 times the violation. It clarifies that if a penalty is assessed to an individual, a treasurer, or candidate, the committee can pay the fine. It also increases late fees and civil fines for big money reports at critical times. The pre-primary and pre-general election reports, if they include contributions or disbursements of over $100,000. And the 24-hour reports due just before the election, reports from self-funded candidates, and electioneering communications over $25,000. And for both of these, if it is a willful violation, the late fee or civil penalty would be doubled. I did share this language with several of the members who raised questions at the last hearing, and hopefully this amendment, the A14, addresses those concerns. And Mr. Sigurdson is also there in the room to answer questions.
All right, thank you, Senator Port. And yes, Mr. Sigurdson from the Campaign Finance Board is present at the testifier table if there are any specific questions. Mr. Sigurdson, did you want to add anything at this time or just want to be available if there are questions from the committee?
Mr. Chair, I'm just available for questions, sir.
Thank you, sir. All right, is there any discussion on the proposed A14 delete everything amendment before we take action on that from members of the committee? Senator Pappas.
Thank you, Mr. Chairman. I appreciate Senator Port settling on willfully and also adding the language up to and focusing on the more egregious violations. So happy to support the bill.
Senator Holmstrom.
Thank you, Mr. Chair. I have one question on page 2, line 4 of the A14. This is giving the board the ability to deposit any funds over $49,000, so past the first $49,000, into their own account versus the state general account, or the state general fund. And I guess I'm just wondering why that's in there. If the elections, if this department is underfunded, they're certainly willing or capable of coming to the legislature and asking for more funding. Is there a reason you've included this?
Senator Port.
Thank you, Mr. Chair and Senator Holmstrom. Yes, the reason that we did that is not the account that funds the CFB. It's the account that's used for public funding of campaigns. So where the subsidies and such come from to help bring more public funding, less reliance on PAC and donations money to candidates. So we felt like these are direct violations to that transparency and understanding of the public to hear directly from candidates. And so this money, over and above what already goes into the general fund, can help to increase that transparency and the voice of voters and candidates.
Senator Holmstrom.
Thank you, Mr. Chair. I guess I can appreciate that, but I think that people of Minnesota, if campaigns are committing such grievous errors and misdeeds that we need to fine them this much money, I don't think it's going to be taken well that we use the money they give us to give to other campaigns. In my opinion, it should all just go to the general fund, but obviously you're the author and I don't have an amendment, so I'll leave it there.
Any further discussion on the proposed A14 amendment? Senator Limmer.
Thank you, Mr. Chair. Senator Port, I noticed that in the delete everything amendment, there's an effective date, whereas the original bill does not have it. Could you explain the effective date in this case?
Senator Port.
Thank you, Mr. Chair. Thank you, Senator Limmer. We did adopt an effective date of August, I believe August 1st, but maybe it was August 12th in the Elections Committee. And so that is reflected here in this amendment.
And
Senator
Mr.
Limmer.
Chair, this particular bill is talking about campaign donation, donations, expenses, that type of thing, but this is an election year. Does an effective date in the middle of an election year that changes the rules in the middle of the game, is that going to be a problem?
Senator Port.
That was a discussion that we had, thank you, Mr. Chair, and Senator Limmer, in the Elections Committee. And the discussion was around, should we implement it for this year or move it to 2027? The committee agreed and decided that we should start it this year. So August 12th is the day after the primary. So it does give still that pre-primary sort of report room under existing law, but post the primary, it would move into the new law.
Mr. Chair,
Senator Limmer.
does our testifier at the table have any opinion on the enforcement date or the effective date? Yes, it's one and the same, to fall in the middle of a campaign season? Is that a difficulty?
Mr. Seeberger.
Mr. Chair, Senator Limmer, administratively it does provide a challenge. In the fiscal note, I did note that the board would do additional outreach, would spend both mailings and additional training sessions to make sure that committees that were, well, all committees were aware of the change, but in particular committees that were likely to have the type of financial activity that would bring them within the enhanced penalties were contacted and made aware of it. So there is going to be an effort by the board that wouldn't usually occur to make sure that they're aware of this new provision.
And Mr. Chair,
Senator Limmer.
Mr. Seegerson, is there a added cost to your operation for doing that?
Mr. Seegerson.
Mr. Chair, Senator Limmer, yes, sir, there is. The board is going to absorb that cost. We're talking somewhat over $2,000, and the board can absorb that.
All right.
Senator Limmer.
Well, Mr. Chair, I don't have an amendment right now, but I am kind of concerned that changing rules in the middle of an election year where everyone's busy, everyone's concentrating on lots of different stimulus in a campaign year, that we're changing the rules of a campaign book in the middle of a campaign season. I just find that to be somewhat unusual. I suppose everyone can violate the spirit of this bill up to August 11th, and then change their rules after that. I just find that to be, I've never heard of it being done in campaign law. We're always very cognizant of the fact that you should establish your rules of play, and it extends through to Election Day or to the end of the year. And it just seems highly unusual. Matter of fact, I think I would like to change the date if I can. Is that part of our jurisdiction, Mr. Chair, to consider a change in the effective date?
It would be about violations and penalties and fines, and so we believe that it is within the committee's jurisdiction. But I have a follow-up question to your comments, if I might, Senator Limmer, before you propose an amendment. Mr. Sigurdsson, what are the report dates or statement dates between today and August 12th? And then what would be the next report and statement date due after August 12th? What I'm getting at is how much preparation time would the people preparing the reports have between now and then to be able to conform themselves to the law and hopefully avoid any penalties?
Yes, sir, Mr. Chair. Give me just a moment to get turned to that part of the statute, please.
Mr. Chair, if I may.
Senator Porter.
Thank you. I would also like to point out that these are not new laws. They are new penalties. So the existing law already exists. We are not changing what campaigns need to do. This bill only changes the penalties.
All right. Thank you, Senator Porter. Mr. Sigurdsson.
Mr. Chair, the pre-primary report due 15 days before a primary election, and of course I don't have a calendar with me, that would be the first report that this comes into effect. There is also a first quarter report which has already been filed, and then a second report filed for the period covering May 31st to June 14th. And then so this would be two reports out, the pre-primary report 15 days before the primary election. So there is basically two reports that will occur before this would go into effect.
And when is the report immediately following the proposed August 12th effective date?
That would be Mr. Chair, that would be the pre-primary general election, which is 42 days before the general election.
No, not the pre-primary report, but after that.
Correct. The first one would be the one 42 days prior to the general election. The provisions do not apply to the year-end report.
Okay, so general election is November, so we're talking mid-September?
Correct, yes, sir.
And then there'll be a post-general election report. Would that be the end of your report?
That's correct.
All right, I guess it just seems to me that depending on when this becomes law, there's ample opportunity to understand the penalties have increased. And as Senator Port indicated, it's not changing the substantive law at all. It's just changing the penalties. So I guess I'm less concerned about the effective date here than I would be if we were actually changing the legal requirements. Senator Limmer, what are your thoughts?
Mr. Chair, I'm glad we had this discussion. I have a better understanding of it now. Since it's just changing penalties and threshold, or not thresholds, penalties, I'll withdraw my suggestion.
Senator Holmstrom.
Thank you, Mr. Chair. I want to bring it back to that special revenue fund. I couldn't leave it be. Wondering if you might be able to answer how that money will be separated into campaigns, because right now it's the money in that fund is done by a box you check on your taxes, and right now, in 2024, nearly 60% of that money went to one party and 40% went to a different party, without saying which parties those are. But I'm concerned that the math on that might be, again, I'd like to know how you plan to do it.
Mr. Sigurdsson?
Mr.
Is that who
Chair.
you're directing your question to, Senator Holmstrom?
Yes.
Mr. Sigurdsson.
Mr. Chair, Senator Holmstrom, this is going into the general account of the state elections campaign account. There are two accounts. One is the party account, which does reflect the checkoffs from the tax form, and that is by party. The general account is by office, and so that's split evenly between every candidate within a particular type of office, regardless of parties. So there wouldn't be any partisan division. It would be divided up by the number of qualified candidates for Senate and the qualified candidates for the House.
Senator Holmstrom.
Thank you.
Any further discussion on the proposed A14 amendment? I'm not seeing any. Senator Westland would move adoption of the A14 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Is there any further discussion on the amended Senate File 4196? Members, the proposed action here is to send this to Finance. Not seeing any further discussion, Senator Westland moves that Senate File 4196 as amended be recommended to pass and be re-referred to the Senate Committee on Finance. All those in favor say aye. Aye. Opposed? No. Motion prevails. All right, thank you.
Thank you, Mr. Chair.
So, members, we got a couple of options here. Senator Koran is present. And apparently needs to leave in fairly short order. This is on Brady-Giglio. We can tackle this right now, or we can take a break for lunch and cake. Senator Koran, you want to be in the way of getting lunch and cake? Come on forward. I know you've got a timeline. We'll tackle Brady-Giglio. Members, if you want to step out to grab a bite of cake, that's fine. After this is done, we'll take a short break for lunch. Members, the bill packet is being distributed. Senator Koran, our members, the plan here is to move this on to Finance. This is our first committee of jurisdiction. There are two amendments in the packet that are proposed. One, delete everything, and one amendment to the delete everything. So we're going to treat these both as author's amendments to put this into the shape that the author of the bill wishes for it to be considered. So first we'll have Senator Pappas or Senator Limmer. You want to move the A2 to the A1?
I'll move the A1, Mr. Chair.
Senator Limmer moves adoption of the A2, amending the A1. All those in favor say aye. Aye. Opposed, motion prevails. The amendment's adopted. Senator Limmer also moves adoption of the A1 amendment as amended. All those in favor say aye.
Aye.
Aye. Opposed, motion prevails. The amendment is adopted. We now have total bill in front of us consisting of the A1 amendment as amended by the A2 amendment. Senator Koran, why don't you start telling us what this bill does?
Thank you, Mr. Chair. I appreciate the consideration prior to taking the lunch break. And so...
It might affect the outcome, by the way, but you've taken that chance.
Mr. Chair, I didn't want to imply that, but I thought there was a guaranteed favorable opinion for allowing us up here. Thank you. Thank you, Mr. Chair, for hearing Senate File 325. This bill seeks to regulate the process by which prosecuting agencies place and remove peace officers from the Brady-Giglio lists. It establishes clear, uniform standards to ensure fairness, transparency, and consistency across Minnesota. The language before you has been carefully negotiated among key stakeholders, including the MPPOA, the County Attorneys Association, the Sheriff's Association, the Minnesota Chiefs Association, and Law Enforcement Labor Services. This collaborative effort reflects a balanced approach to a very complex issue. Currently, there is no uniform process. Policies vary by jurisdiction, creating unnecessary uncertainty for our law enforcement officers across the state. The standardized framework is essential to eliminate these discrepancies and ensure consistent treatment. Law enforcement agencies in Minnesota need a clear, consistent, and fair process when it comes to Brady-Giglio designations. Just as importantly, officers must have a defined and fair avenue to challenge such designations. Protecting due process is critical, not only for the officers involved, but for maintaining trust and integrity in the system as a whole. And with that, Mr. Chair, I'd like to turn over to our expert witnesses.
Who wants to go first? Ms. Haas, go ahead.
Chair Latz and members, Nancy Haas on behalf of Poole Haas and the Minnesota County Attorneys Association. This bill and this work is our association's top legislative priority this year. And the delete all amendment before you is a reflection of really a years-long dialogue. And in particular, we spent the last 6 months in earnest working with law enforcement and our prosecutor partners to get to this point in this language that you just adopted. MCA has also led other stakeholder outreach. Specifically, we have engaged with MAPE, AFSCME, the League of Minnesota Cities, the Board of Public Defense, and the criminal defense lawyers. At this time and through this work, no one has requested further language changes. However, I would note after receiving an initial fiscal note from the judicial branch, we have been engaged in further dialogue with them about assumptions and potential modifications to the language to better give guidance to them and inform a possible updated fiscal note. We hope to continue to do that work as this bill moves to finance, as you noted. And as with all things of this magnitude, we remain open to hearing from others in terms of possible tweaks as we move forward. With that, I would turn it over to John Holitz from St. Louis County to talk about the outline of the bill.
Mr. Holitz, thanks for driving down here.
Thank you, Mr.
Welcome
Chair.
to the committee.
Yeah, thank you, Mr. Chair. Thank you, members. I am, as the introduction was, I did come from Duluth, Minnesota this morning. I'm here from St. Louis County on behalf of the Minnesota County Attorneys Association. The weather was better up north this morning than it is here. I rarely get to say that, so I'm going to gloat on that. Ms. Haas is right on the efforts that have been put into making this comprehensive, bringing people together and bring this to you today. They've been extensive. They've been painstaking. We are trying to bring everybody together to consensus on this. The consensus that we're working for is for something that's consistent, predictable, simple, and secure. This bill is good for all parties, all concerned, for public employers, public employees, the judiciary, defendants, the public and private defense attorneys that we work with, and of course, prosecutors, both municipal city prosecutors and those who MCAA represents, county attorneys. The kind of the overarching philosophy of the bill is, in exchange for the important data access that prosecutors need, is some assurances on the protection of that data that we access. And that's kind of the rub of the bill in the way that it's set up. That's how we make things consistent, predictable, simple, and secure. My intention today is to go through some of the language with you and just highlight a few things that it's contained within the bill. I intend to skip over subdivision 1 because I know there's cake on the menu, and subdivision 1 is definitions. I think you can see that we were attempting to mirror language in chapter 13, again, to make things consistent. Moving to subdivision 2, we're talking about the contents of the prosecuting authority policy, and this is setting some sort of floor requirements that prosecutors should have in order to get access to that data. This is highlighting consistency and predictability for public employees who we call as witnesses. What it does not do is it does not say what precise policy everyone has. While MCA will put together a toolkit, and it has put together a toolkit that people can borrow from to use to comply, we know that it's not right to tell Big Stone County what they need to do and what's right for them. Just like it's not right for, say, Ramsey to tell St. Louis what St. Louis needs. We've got 87 different counties, and then we've got municipal prosecutors, all with different
different needs. And so this puts some floor minimums, some assurances, but it does not mandate a specific policy. But it gives us some of those basic elements. It also gives that consistency and predictability to those people those public employees who are often witnesses. And they can be witnesses in many different counties. They can be witnesses for different prosecuting authorities. So having those bare floor minimums for prosecutors allows that public employee to have some certainty when they move and testify in a different jurisdiction. Moving to subdivision 3, again, this is highlighting that consistency and predictability that we're seeking to create. This is the prohibition on do not call lists. Prosecutors should not be in the position of saying that a public employee could never testify. We work with all types of witnesses. We call all types of people with various criminal histories as witnesses, as prosecutors. Sometimes crimes require that because that's the best witness we have. We should not be saying because of a person's impeachment data, we will never call them. We should be saying if they have that impeachment data, we need to get it and we need to turn it over. But we shouldn't be saying you shall not ever testify again. That's following our obligation as prosecutors. Moving to number 4, subdivision 4, we're talking here about data access. This is the jewel of the bill for the prosecutors. This is what I particularly care about. This is the simplicity piece for us. Right now, we're at odds when it comes to data that is non-public. We're at odds with Minnesota, with the Government Data Practices Act, Chapter 13. It makes things very difficult. It really stands in our way of accessing that data. This allows that limited access for prosecutors to work with those municipalities, with those public employers, to get access to that data, to look at it themselves and do their required Brady analysis themselves, as opposed to having to do a whole bunch of motion practice, go to a judge, get the judge to order it to us, and then do it. The difficulty of that, of course, is there's many different judges with many different opinions, and so you could have inconsistency, and that's what we're trying to avoid. We want to get access to that data. We want to be able to review it. We want to be consistent and predictable. This makes it simpler for us to do. Moving to subdivision 5, this is the restrictions. This is that security that we're talking about. These are the ways that we make sure that the data that is on public employees is protected when it's with prosecutors. This leads to greater predictability and security of that data, which is very important to public employees, myself included. So that's what subdivision 5 attempts to do. Subdivision 6 is a penalty section. It's something that we are working on with our partners currently to try to ensure that that data that is given through the discovery process, subject to Rule 9 of the Minnesota Rules of Criminal Procedure, is used in the way, and only the way, that Rule 9 says it's supposed to be used. That's important, and it should be important to prosecutors, and it's important to law enforcement to make sure that these things are not used to harass, not used to embarrass, but used for litigation, because that's the point of it, and that's the only reason that that stuff is being transferred. Subdivision 7 is a discussion about judicial notice. And that's another subdivision that we're currently working on with our partners to determine how best to do that. The note I will say about subdivision 7 is that is an attempt, again, at making this predictable for us, having the court provide to us and be intentional in the orders that they issue. So those are the subdivisions that I was hoping to highlight today, and I would be happy to answer any questions, and thank you for the opportunity.
Thank you, Mr. Holitz. I'm going to note also that in addition to the materials or letters that were distributed in the members' packets, there are some more letters being printed and distributed, including a letter from the Minnesota Association of Criminal Defense Lawyers. And also, I understand the Board of Public Defense was notified about these and has not expressed any concern or opposition that I'm aware of. We do have some additional testifiers have signed up to testify. Dave Titus from the MPPOA and Kevin Beck from the MPPOA, if you both like to come forward.
Welcome, gentlemen. Thank you, sir.
And members were distributing a memorandum that apparently will be referenced by the testifiers. Mr. Titus, would you like to start?
Yes, Chair. Thank you, committee members. Senator Westland, the description of that cake sounds absolutely fantastic. So thank you for sharing that with us, even though we won't be able to taste it.
Yeah, he's soliciting a
Yeah.
sample.
You're exactly right, Chair. I'll be brief. I'm David Titus. I am the Executive Director of the Minnesota Police and Peace Officers Association and a retired 30-year St. Paul cop. I will not duplicate others' extensive testimony on why there is a statutory need for a fair, consistent, uniformed process of Brady application, but instead our path to agreement and our support of Senate File 325. County attorneys, chiefs, sheriffs, the MPPA, these associations represent their respective professions, their members' priorities and interess. The MPPA represents only rank and file licensed peace officers. Our position on this Brady bill has been consistent. We need a fair, uniform Brady process. The MPPA introduced Brady legislation in 2022, resulting in the above association's collective, extensive, exhausting debate that ultimately established what we believe is a clear, fair, known roadmap for Brady application. The MPPA asks for your support of Senate File 325.
Thank you, Mr. Titus. Mr. Beck.
Thank you, Mr. Chair, members of the committee. My name is Kevin Beck. I'm a labor attorney in St. Paul. I'm here to talk about this bill and specifically Subdivision 3. Brady-Giglio is something that's been around since the early 70s, but really in the past 10 to 15 years, the process for what that has meant as a practical matter has changed. And Subdivision 3 will address the material difference between a public employee who is blanketly designated that they will never be called and a public employee who will be determined by a prosecutor on a case-by-case basis whether they will be called to testify. It's an issue of fairness, and this bill will provide protections to public employees, not just police officers, but any public employee who will have to testify or who does testify, probation officers, potentially corrections officers, child service workers. All of these public employees who testify will have more protection if this bill is passed because they'll be able to testify without preemptive determinations, and prosecutors will have to comply, as Mr. Assistant County Attorney for St. Louis County talked about, with their obligations to make Brady witness determinations on a case-by-case basis. For that reason, I ask that you pass this bill. Thank you.
Thank you, Mr. Beck. Any questions for Mr. Titus or Mr. Beck before we go to the next testifiers? I'm not seeing any. Thank you.
Thank you.
All right, well, we'll call Chief Henthorn from Richfield forward and County Attorney Johnson from Anoka County to come forward as well. Chief Henthorn, welcome back to the committee.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Jay Henthorn. I serve as the Chief of Police for the City of Richfield and as the immediate past president of the Minnesota Chiefs of Police Association. I'm here today representing over 300 chiefs of police and over hundreds of command staff members from across Minnesota. First, I want to thank Senator Koran for bringing this bill forward and Chair Latz for placing it on the agenda today. We appreciate your leadership on this important issue. I'm here to express the Minnesota Chiefs of Police Association's strong support for Senate File 325. Quite simply, this bill addresses a problem we see every day, which is inconsistency and which has been talked about by the previous testifiers. Right now, there's no uniform standard for how Brady-Giglio material is handled across Minnesota. Practices vary widely from one jurisdiction to another. That inconsistency creates confusion for officers, challenges for prosecutors, and uncertainty for the communities we serve. When the rules are unclear or applied differently, depending upon where you are, it undermines the confidence in the system and makes an already complex process even more difficult to navigate.
Senate File 325 brings much-needed clarity and structure. This bill is the result of collaboration with the County Attorneys Association and other justice system partners, and it reflects a balanced, thoughtful approach. It does three important things. First, it clearly defines key terms so everyone is operating from the same understanding. Second, it requires prosecuting authorities to adopt written policies, ensuring a consistent and transparent process for determining and handling Brady-Giglio material. Third, it establishes clear guidelines for how this sensitive data is accessed and secured. Combined, these provisions create a framework that promotes fairness, consistency, and accountability across the state. This is not about changing the standard. It's about making the standard clear and consistent for everyone. On behalf of the Minnesota Chiefs of Police Association, we respectfully urge you to pass Senate File 325 and move this important work forward. Thank you for your time and the opportunity to testify today.
Thank you, Chief.
Thank you.
Any questions for the chief while he's present at the table? Not seeing any. All right. Thank you.
Thank you.
Mr. Chair. Mr. Chair, I think you had
Senator
Mr.
Koran.
Johnson on the testifier list. He had to leave.
Oh, all right.
He didn't get the notice on the cake.
All right, and we do have one person signed up to testify in opposition, John Beeler from the ACLU, I understand. Come on forward, Mr. Beeler. And I also understand Claire Dibble from the head of the county attorney's office is present to answer questions. Mr. Beeler.
Thank
Go
you,
right
Chair
ahead.
Latz, members of the committee. We're here to testify on behalf of the ACLU Minnesota, where I serve as the policy counsel, but also with the Legal Rights Center, who could not make it today. We don't object to the streamlining of data provisions and the sharing between the government entities contemplated in this bill. However, there are unnecessary additional provisions providing data protections and criminal penalties that we do not believe were thoroughly thought out, and would like to highlight a few of those. Lines 3.21 to 3.29 provides law enforcement an opportunity to object to these Brady-Giglio designations. This carve-out reintroduces and statutorily codifies the exact same problem that the bill is purportedly trying to solve. Currently, the state spends valuable time and money fighting with itself, county attorneys and law enforcement, and with defense counsel about turning over material. The judiciary clearly agrees. Their fiscal note anticipates that in 12.5% of cases, they will have a Brady-Giglio dispute, which equals nearly 20,000 cases at 20 minutes of time per case, 5 full-time judges worth of caseloads, or a $3 million annual cost. I understand that fiscal note has been asked to be revised, but I have not seen an updated number. And those numbers come from the discussion section in that fiscal note. Our greatest objection is on lines 428 to 433, which does not define recipients in the Brady-Giglio material. Similarly, so that means defendants, defense counsel, jurors, journalists can be criminally prosecuted for commenting or publicizing Brady-Giglio material even when it is lawfully obtained. There is no mens rea component to this, so inadvertent disclosure of material is as criminal as intentional disclosures, which is a stronger protection and stronger penalty than that contemplated in the Minnesota Government Data Practices Act. Notably, there is a protection in subdivision 8 for judges and prosecutors that overlaps with this, so that piece clearly in subdivision 6 will be used to threaten and prosecute defense counsel, journalists, and defendants for discussing matters of public interest, i.e. when individuals are Brady-Giglio compromised. We don't believe in the necessity of subdivision 3. We don't believe do not call lists or do not use lists are being used anywhere in the state by any prosecuting authorities. We think it's a necessary addition, not a strenuous objection, but would like to know whether or not they are in use and whether or not they're necessary. And then lines 2.25 and 2.27, I apologize, have been jumping out of order. That is subdivision, section 1, subdivision 2.7. These procedures, and speaking with some line attorneys, are concerned that this creates a higher standard for defense attorneys and other parties. Defense attorneys may be restricted in using knowledge they obtain in one case in defending another case. Those are our objections. We are happy to continue working with the authors and the other party involved on this bill, but we will stand for questions if there are any.
Mr. Beeler, thank you for your testimony. I'm a little bit confused because I was under the impression that all of the stakeholders that had an interest in this bill were either not objecting or were supporting it. And now I've got a letter in front of me dated April 16th that and your testimony today, which indicates otherwise. Can you give me some idea of the timeline here on your involvement and you're coming forward with the objections? Mr. Beeler.
Yes, Chair Latz. I can't speak for the Legal Rights Center on whether they were contacted, but to my knowledge, and I am only been at the organization for about 6 months, the ACLU of Minnesota has had no requests for feedback on this particular language.
So when did you become aware of this particular language?
At the House, Chair Latz, at the House introduction of the similar language earlier this week.
Earlier this week? Okay. Thank you. All right, Senator Oumou Verbeten, did you have a question for Mr. Beeler while he's up there? Mr. Beeler, don't go away yet. Senator Oumou Verbeten.
Thank you, Mr. Chair. I think my question might be for Mr. Beeler. Also, Mr. Holitz, potentially the, just the County Attorney Association, and then Ms. Dibble, if she's here, might want to weigh in as well. I think when we heard some versions of the bill previously, one of the things that came up was, of course, that prosecutors have this constitutional duty to provide the Brady-Giglio material. And then there's concerns about data access, and then the material that they may receive sort of being used just for that purpose of Brady-Giglio. But when I'm looking at starting on line 3.27, where this kind of goes through the process of if there's an objection and the court needs to look at whether the prosecutors complied with subdivision 2, which outlines generally that they need to create a policy around it, I think is my understanding of how this bill approaches it, but not the specific policy. And then to whether that objection relates to the data that may be favorable to a defendant or impeaching of a witness. Basically, the scenario I'm concerned about is, what if it is Brady-Giglio material, but the policy that we're kind of outlining in this bill wasn't followed? You still have that constitutional duty to provide the material. But if you didn't follow the exact correct policy, what happens?
Mr. Beeler.
And if those folks want to weigh in, I just want to make sure that the policy doesn't get in the way of prosecutors having access to the information that they have a constitutional duty to provide.
Mr. Beeler.
Chair Latz.
Mr. Holitz as well.
Chair Latz, Senator Verbeten. I can't comment on how the interaction between the county attorneys and the public employer would work in this situation for violations of the policy, but I would note that the constitutional obligations to turn over this material are paramount and would take precedent.
Mr. Holitz.
Thank you, Mr. Chair. I saw you looking at me for the question, so I hope that I'm in the right spot here. I agree the constitutional obligation is there, and you know whether there is a bill or not, the constitutional obligation, the due process obligation is there. It has been there. It will remain there. This is why the data access part is so paramount and important to prosecutors in terms of getting access to the stuff that we have to get, getting access to only the things we have to get access to, and turning over the things that we have to turn over. And so anyways, the question about what happens if the policy is not followed, that's back to the intention of giving some basic minimum floor requirements to this policy, because like I said, we can't dictate, and we shouldn't dictate based on which on these individual prosecutors what their needs are. The needs, like I said, in Big Stone is very different than St. Louis, and our neighbors in Carleton, or my neighbors in Carleton County, is very different than St. Louis, just like it's very different in Ramsey and Hennepin. But we have, we want to give guidance, give direction, and give some floor minimums. If the law enforcement agency thinks that the policy does not follow the proposed bill, I think that's the time where we tried to build in this limited ability to resolve those disputes with a strong favor on get together with the agency prosecutor and try to find a solution to this before you get the court involved. I hope that answers your question.
Senator Oumou Verbeten.
Thank you, Mr. Chair. I was just wondering if Ms. Dibble wanted to weigh in as well.
Is Ms. Dibble present? Come on forward, please.
Address any other questions.
Go ahead and introduce yourself for the record.
Thank you very much, Chair Latz. My name is Claire Dibble. I'm the Director of the Division of Professional Standards at the Hennepin County Attorney's Office. Thank you for giving me the opportunity to answer questions today. Chair Latz, Senator Oumou Verbeten, was there a specific question? Would you like me to follow up on your inquiry regarding the, I believe your inquiry was whether it would be possible that anything we're laying out in the statute could prohibit us from disclosing something we'd otherwise be able to disclose. So we have the HCAO, Hennepin County Attorney's Office, is supportive of this bill. And we believe that the way the subdivision regarding the policy is structured allows us enough flexibility to be able to make the decisions that we need to make under the federal Constitution. And of course, if there were to be any conflict, the federal obligation would trump the state law. But the way that this was written is enough to allow us flexibility to meet our constitutional obligations. And I could give just one example. Among the prosecutors' offices, I think there are variations on what prosecutors believe they need to disclose. For example, if there is, like we could use a seatbelt violation, for example. If there was an officer who had been disciplined for a seatbelt violation, we would not have a category at the Hennepin County Attorney's Office that would require disclosure of that, because our categories are things like truthfulness, inventory, issues where we would be concerned that a case could be affected. But those categories, whatever prosecutors kind of try to use to filter what they need to disclose, aren't in here. And it's a good thing they're not in here, because we may have a case where an officer not wearing his seatbelt could be relevant. We had a drug case where that actually, one of our attorneys came to us and said, I know we don't usually disclose seatbelt violations, but in my case, it could be relevant. So for that reason, we don't believe that the language is such that it would interfere with our ability to disclose Brady information.
I'm going to note, per my earlier question, that the bill was introduced January 21st of 2025. And we may have had an informational hearing last year, perhaps. I don't recall exactly. Well, on Brady-Giglio, generally, I think we did last year. So I'm a little bit concerned at what I characterize as a kind of a late arrival objections, but I don't want to dismiss the value of the objections as well. And so maybe we can get a little more of a response to Mr. Beeler's concerns, especially about subdivision 6 and whether that would create any issues for defense counsel or journalists or defendants who are in the public arena outside of the actual criminal proceeding, making statements about the lack of credibility of witnesses because of Brady-Giglio violations.
Mr. Chair.
Mr. Hollins.
Mr. Chair, yeah, last year you did hear a version of the Brady-Giglio bill. Wasn't this version, or as this Senate file, but the delete everything was a conclusion of the work done since that time to bring peace in the valley. And so this is a result of what we're looking at today is a result of the work since then.
Thank you, Senator Koran. I understand the delete everything is quite new, but it sounds like maybe we can get some feedback on whether parties that have now come forward with objections were involved in the process or consulted along the way. They're pretty significant stakeholders here. Ms. Haas.
Thank you, Mr. Chair. I would just say the first time the delete all amendment came forward was about 3 weeks ago. So I just will say, it is relatively new. I will say also that both the County Attorneys Association and some of our partners have reached out to others. And so I know in particular the Hennepin County Attorney's Office had engaged with the ACLU. Having said that, I also, not these specific objections in this moment, and I think we can speak to the interest and the idea of trying to address some of those, both today and or to the future, because there's some of the things that we have been working on related to the fiscal note and to address that. But I will let my colleague comment specifically on the legal pieces of the mentions in the letter.
You're referring to Mr. Holitz?
Yes, please.
Mr. Holitz.
Thank you, Mr. Chair. I want to go right to subdivision 6, which is where I think your question was. As I stated previously in my testimony, the purpose of disclosing this data is for use in litigation. What we are trying to, what MCAA is trying to prevent is the unlawful use of this type of data to harass or embarrass the stuff being put on Facebook, the stuff being shared, in order to intimidate, harass, embarrass public employee witnesses. As Ms. Haas said, we are certainly willing to work with folks on crafting that language to get to that purpose. What we are trying to do is look at what Rule 9 of the Minnesota Rule of Criminal Procedure tells us, and that it's to be used for litigation and be guarded by the parties as such. And so that's what we're trying to embody there. Again, very much willing to work with others on perfecting that language.
Well, certainly subdivision 6 doesn't say anything about harassment or intimidation. It talks about disclosure without any limitation on purpose of that disclosure. So I can imagine a journalist that sits in on the trial or on a preliminary proceeding for the trial, and it becomes apparent in that public proceeding that there's a potential witness in the case that has Brady-Giglio issues. It sounds like the journalist would be prohibited from writing anything about that, broadcasting anything about that in their coverage of the legal proceedings without running afoul of the misdemeanor penalty that's here in subdivision 6. Am I understanding that correctly, Mr. Holitz, or am I misinterpreting it?
Thank you, Chair. I think you're misinterpreting it, and that's not our intention. So I'm thankful to hear that feedback on that. We're talking about the data itself, the protection of the actual data, not its use in court. Nothing in this bill should be construed to limit the use in a public proceeding if the court has so ruled. In that case, it's public. And so that is not the intention of subdivision 6. The subdivision 6 is the intention to safeguard the data before it has gone to that step of admissibility in a court hearing. Safeguard it while it's in the discovery process, while it's still subject to Rule 9 and the intentions of Rule 903, where it talks about that the use of this is for litigation and purpose in litigation. Obviously, or I guess not obviously, once it's ruled admissible, used in court, talked about in court, that's a whole different circumstance, the public nature of that proceeding. So thank you for the feedback on that.
Well, yeah, I'm just reading it. It just says, shall protect the data from further disclosure outside of the criminal action. So it doesn't say after it's been publicly disclosed in the criminal action, or it doesn't say only before then either. So, and I mean, I can understand the concerns about the fiscal note and how often would this be used, and clearly there's a certain amount of judicial time already being used in motions. And I haven't read the fiscal note carefully, and that's something the Finance Committee is going to have a chance to sort out. So how much of a change would there actually be from current practice, is something that I think the Finance Committee can handle from that standpoint. But in terms of the policy provision here, I guess I'd be curious to know whether Mr. Beeler, who was here speaking on behalf of himself and on behalf of Anna Hall at the Legal Rights Center that submitted the letter we have in front of us, if his view is that I'm addressing or I'm understanding the concerns correctly, if that needs clarification, that needs to happen in this committee before it moves on. Because we're not going to send the Finance Committee responsibility to sort out a judiciary provision. So, Ms. Dibble, do you have something to add?
Thank you, Chair Letts. Yes, I do. With respect to the judicial impact, I just wanted to share that in the Hennepin County Attorney's Office, we filed 1,034 motions last year in criminal cases to get access to this data in order to comply with our Brady-Giglio obligations. Over that year, we received 7 objections from law enforcement of the over 1,000 motions. If this bill was passed or would have been in place last year, we would not have had to file those 1,000 motions to compel, and we would only have had to deal in the courts with 7 objections. Additionally, we would be seeking motions for protective order. We also, it's a joint motion, so 1,000 of those. We would be going to court to seek a protective order, but it would be in far fewer cases because it would only be when we would need to disclose private data. It's my understanding, I'm not attempting to speak for the judiciary, but it's my understanding that the fiscal note was based on a prior version of the bill that did not allow data access. So it makes sense that without data access, what's happening in Hennepin would be happening across the state, and that would really impact the courts. But our interest in this bill at the Hennepin County Attorney's Office is to take this process out of the court system and give the judges their valuable time back to adjudicating criminal cases and not reviewing motions for disclosure of private data.
So, Ms. Dibble, my understanding as well is that the fiscal note was drafted to the original introduction and not to the delete everything amendment. So I think certainly they'll need to revise, review, or redo the fiscal note before it gets to the Finance Committee. So they'll have that full information. Mr. Turner, am I correct on that?
Mr. Chairman, yes, and I put in the fiscal note request 5 minutes ago.
All right, let's see how quickly they can move. I know we have Mr. Potts present, and I know Senator Westland's also wanted to ask a question, make a comment. I'm not quite sure where this will fit in. Senator Westland, should I go to the testifier first? Okay, go ahead.
Thank you, Mr. Chair. Again, Jeff Potts from the Minnesota Chiefs Association. I just wanted to try to clarify and maybe add some context to Subdivision 6 and why it's there, what we're actually trying to accomplish. Appreciate the interpretation, Chair, that you had made, that with the Subdivision 4 provisions, which is the access to data, as you know, that will likely include non-public data. And in the exchange, in trying to make sure we at least adhere to the spirit of Chapter 13, that's why Subdivision 6 is there in terms of the penalty for, again, once it gets to a trial, we recognize that that becomes public. But in the process of establishing whether or not it's Brady material, what we were hoping to do there and trying to do with the way it's worded is protect that data as private data or non-public data. And those, as you see in in Subdivision 6, that penalty provision is just simply trying to do that, is maintain that data and prevent that from being further released because it is private data. If there's another way, Chair, to do that, whereby we could make some type of an amendment to accomplish what we're trying to, I think we're certainly open to that, but certainly wasn't the intent to subject journalists to criminal penalties for covering a story that they hear in an open trial.
Mr. Potts, Mr. Beeler identified 3 categories of people that they thought might be swept up in this, journalists, defense counsel, and defendants, as I recall. So it's going to be my intent here, because we're going to take a break for lunch, and we are going to have other bills to be heard, is that we're going to give the parties an opportunity to have further conversation today to see if the language can be fine-tuned a little bit, or maybe Mr. Beeler's concerns are based on a misreading or misunderstanding of the language that's in the delete everything amendment. But I want the parties to have time to talk about that and see if we can reach agreement here today before, because I'm not going to, as I said, we're not going to pass the bill on to finance to figure this out. So let's see if we can address it here today. Before we lay the bill on the table, is there any members of the committee want to have any input? All right, I'm not seeing any. So for the moment anyway, Senate File 325 is laid on the table.
Thank you, Mr. Chair.
Thank you, Senator Koran. We're going to recess for 30 minutes for people to get a bite to eat, and then we'll reconvene, let's say at 1:05.